Well, I have been asking, my lord.
Heard Mr. S.M. Abdullah Learned, counsel appearing for the petitioner. The records called for from the respondents are yet to be received. List again on. When should we have it?
my lord.
Huh?
Somewhere in September.
14th of September.
Oblige, my lord. Interim order may continue.
Interim order passed earlier continues.
Oblige, my lord.
May I please, Lord? I beg to mention item number 46, Lord.
46
This
years.
is Mr. A.M. Bora, Lord. So he's not keeping well today, Lord.
Okay.
Can it be any date next week, Lord?
Next week.
But next, as per the court's convenience,
We'll have it on 31st August.
31st.
Okay. At the request of the learned counsel appearing for the petitioner. List the matter again on 31st of August.
So the
CD
interim may kindly be
Huh?
interim may kindly.
Interim order passed earlier continues. We don't have the CD list to do, na? What do you say?
Deeply obliged.
Yes.
May it please your lordship, I beg to mention item number 30, lordship.
30.
30, lordship.
Mr.
K. Burua, actually, his wife has been admitted to maternity hospital, lordship.
Okay.
So, any date next week?
At the request of the learned counsel appearing for Mr. K. Burua, learned counsel for the petitioner, list this matter again on the 31st of August. 31 August.
May it please, your lordship.
Yes.
Lordship, with the consent of the other side, I beg to mention item number 22, lordship.
22.
Lordship, lordship,
Yes.
this matter may kindly be passed over for the day, lordship.
At the request of the learned counsel appearing for the petitioner,
Petitioner, lordship.
who has taken the consent of the learned counsel for the respondents, list this matter again on 7th of September. 7th September.
Lordship, interim order.
Interim order continues.
Obliged, your lordship.
May I please, your lordship. I beg to mention item number 40. On last occasion, 10th of August, of CD was called for, but today the CD is not available. Kindly given a short date because he's behind our modern.
Item number?
40.
Yes, someone is behind bar, sir.
Lordship. 31st, lordship.
Heard the learned counsel appearing for the petitioner. Learned APP submits that the CD is awaited. List again on
31st.
31st August.
Must have been. Lordship. May I mention item number 32, Lordship?
32.
Yes, Lordship.
Yes.
We are for the petitioner. The amicus has informed that due to her some difficulty, she will not be able to conduct the matter today.
Hmm.
So that's why seeking date anytime in the next week.
At the request of the learned amicus, which has been informed to the court through the learned counsel for the petitioner, list this matter again on
Next week, 28, 29.
28,
20.
31st. Have it on 31st. 31st.
Lordship, I also beg to mention another item. Lordship, 49.
20,
49, Lordship.
49.
Yes, Lordship.
Yes.
Some personal difficulty in this matter, Lordship. Can it be adjourned for the group?
At the request of the learned counsel appearing for the petitioner, list this matter again on 2nd of September. 2nd September.
Wait, please, your lordship. I beg to mention item number 50 and item number 56. Kindly pass over it for today and fix it on next week.
We'll have it on 31st of August. At the request of the learned counsel appearing for the petitioner, list the matter again on 31st of August. Separate orders, huh?
50 and 56.
In both the cases, separate orders.
Right,
Yes.
Next. May I please, your lordship? Item number 45.
Hmm.
Case diary as called for has not been received yet.
Learned counsel for the petitioner is present. Learned APP has submitted that the case diary as called for is yet to be received. List the matter again on
On 9th, my lord.
9th of September. Any interim?
Interim
No.
order earlier it has been passed. Interim order earlier in earlier date it has been passed.
There's an interim order.
They must be. So they are.
You check the file. If there's an interim order,
Yeah.
then interim order passed earlier continues. Okay. And if there is no interim order, you show me the file when you're passing when you're typing the order. Yes, next.
Obliged.
Mr. Goswami will continue the interim if there is one.
May I please, your lordship, I beg to mention item number 24 on behalf of DK Badya for respondent number 226.
Ah.
Have taken consent from the opposite party.
Ah,
The matter may be adjourned for today and may be fixed after 2 weeks. And the status report, which has been called earlier, has not been received as well.
scan copy of the TCR has arrived.
Right.
It has arrived, it is there in the cause list, so when do you want it?
After 2 weeks.
At the request of the learned counsel appearing for the respondent number 2, 3, 4, 5, and 6, comma, with the consent of the learned counsel for the petitioner, list this matter again on 11th of September.
Obliged.
My lord, with your
Yes, sir.
lordship's indulgence, I'd like to mention item 20.
20.
They filed an IA application. That's a Gurucharan College matter.
Hmm,
They filed an IA application. It hasn't come yet. I'm just.
just call for it. Call for the eye.
Published.
Hmm.
Wait, please, Your Lordship. My lord, sir, wrongly listed in the motion column. It ought to be in, my lord, in the bail hearing, my lord. If the diary is available, my lord, we'll have it after the motions. After the motion.
Here the order was,
Diary was.
list the matter again on 21A. There is no other order.
Diary was actually, diary.
এইটো সেই বেল হিয়াৰিং লগত মাতি দিব বেল হিয়াৰিঙৰ লগত মাতি দিব চলি থাকোতে
May I please, your lordship? Lordship, the written reply is to be filed today. It is in the process of filing.
Hmm.
So we request you to grant the next date of it.
Well, I have serious objection to this. This kind of practice I do not appreciate from my side, and I think the court will also not appreciate. A person is in jail for 52 days, and the learned counsel who was opposing the bail is also earlier there in another set of petitions where the co-accused were granted bail. And for the sake of justice, procedural safety, time was granted to them as per their request. Till today it was granted, and he is in custody. They are again praying for. What prevents them from filing?
Your lordship, in the.
What prevents from them filing? Kindly look into it. I will press my petition.
The state, it was, the copy wasn't served.
Copy was served on the last date,
So, your lordship, it is reflected in the order of
and
11 copies.
such pleas are only dilatory to just get adjournment. Because, well, the counsel, as I said, the counsel was appearing all throughout, he knows. And a case, well, kindly see, under section 7 and 13, they laid a trap under PC Act. Laid a trap. And thereafter, they arrested me. I was the project director.
Ah.
I was the project director in Shillong. And I was transferred out 4 days before they laid the trap from this office. And I have joined in Rajasthan,
Page 37.
Hanumangarh. And then I came back here because he is a PIL. Well, the whole thing emanated from the PIL. What happened? I may just surprise this honorable court.
Hmm.
The PIL was filed that certain road which was constructed under my supervision, which I being the project director in Shillong, Meghalaya,
Para 16.
para 16 I have stated, there the complainant was the contractor.
Hmm.
And he ultimately made the road. I went for inspection, I found that it was done, and I issued clearance certificate. And thereafter, he submitted bills. But meanwhile, PIL was filed, that the road was not completely done, not well done.
Hmm.
Therefore, court took up the matter. I was asked to come and I said, yes, it was done. When I went there, I found that it was completed.
Hmm.
But then other side, the PIL petitioners, they said, no, there were a lot of potholes there. And I went there and I found that, yes, there were potholes have arisen. And court took contempt against me. Contempt is pending. I came back to face the contempt on that day.
On the next day.
On the next day, when next day was contempt,
Mm.
I came back from Rajasthan
Ah.
and I was arrested here. I was arrested here and he says that I wanted some money to clear his bills because I have not cleared the bills and therefore he was asking for money. Now kindly see, my lord,
Co-accused has already been bailed.
co-accused have been already granted bail.
Please, sir.
And even if I take the worst case, well,
Have you
it
taken
was, money has not come to my hand,
Never.
obviously. it was caught from the other accused. Bali was recovered from the other accused.
Hmm.
They said, they took my name. My case is that, well, when I didn't pass his bill, I didn't pass the bill, therefore, he has laid a trap to fix me. That he is asking for money, that's why he is.
There
not-
is no recovery from you.
No, no recovery from me. And I'm an official, government official, Malad, I'll be there. 52 days I'm in custody. What for more day? More confinement is needed. It is not a punishment, my lord. Documentary evidence, everything in their hand. Therefore, my respectful submission, kindly see the bail order earlier granted by the collateral banks. Kindly see, my lord, ultimately, we cannot forget that the pending investigation, if an arrest is made, kindly go for the order, my lord. Same.
They were released in 36 days, but these days they were released. And 52 days. It's 60 years, 60 years. Is it 60 years or not?
Your Lordship, there is a request on the behalf of CBI.
Sorry?
There is a request on behalf of the CBI since the matter is listed in the category of motion for the first time, since the copies were not served on 11th August, the copies were served after that, and the reply is filed today. It is to be filed today. So the Standing Council of CBI request to accommodate the, to provide a short date either. Or it can be requested
Mandatory
for
period of
timing.
60 days, I have already completed 52 days. My lord, kindly see, court has
Short
given, for
date.
the sake of justice, given an opportunity to them, 2 weeks' time was earlier granted. They have not come up, they should be quick enough here. When a person is taken to custody, authority must be on their foot to place everything before the court as and when it is required. They cannot just keep on buying time. I am sorry to say, my learned junior friend is coming before the court today,
Hmm.
but nonetheless, I am compelled to press my petition. This kind of things, my lord,
Have you filed it?
It is in the
No.
process of filing, Your Lordship.
By
It
what
will be
time?
filed today,
By what time? We'll have the matter at 2.
at 2, yes, let them file it,
Your Lordship.
Ask your counsel to be here. We'll have the matter at 2.
yes.
And court master, if they give you the what do they call it, the slip to call for the written objection, call for it. But we are here till 3:15, I think.
Try our best.
We'll try. Yes, ask your counsel to be here.
Your Lordship.
Huh?
Oblige.
Hey, please, Your Lord. The NDPS case, my lord, shows scanned copy of the TCR may be called for.
Heard Mr. S. Nawaz, learned counsel appearing for the petitioner. Also heard the learned APP. Application 483, special NDPS case number 67 of 2025. Call for the scanned copy of the TCR. List again on 14th
Lordship.
14th of September.
Deeply obliged.
Please, Your Lordship.
Hmm.
This is a small quantity case, Lordship. Small quantity means only 1.5 kg of ganja, Lordship.
Ah.
Intermediate quantity has been.
Intermediate, yes.
I am behind the bar for last 35 days, Lordship.
Hmm.
Matter will be taken up for final disposal, Lordship. FIR is at page 15, Lordship.
Without an opportunity to them, I'll take it up for final disposal.
Because it is, punishment is, Lordship, they are here, they may object, Lordship. Maximum punishment is 60 days, Lordship.
What do you say, Mr. Goswami?
Maximum 60 days, madam.
60 days, Lordship. I am
Hmm.
behind the bar for 35 days, Lordship.
35 days, madam.
And it is only
60 days is
1.5.
Your name is Mithun Nath.
At page 15 of the FIR, Lordship. Page 15, description of the seized article suspected to be ganja weighing 1550 grams, 1.55 kg only, Lordship.
1.55 kg is not a less quantity.
Intermediate quantity.
It is intermediate.
10 years
Intermediate,
punishment.
but
Lord,
it is not
50
a
days.
small quantity.
No, not a
Small
small.
quantity is otherwise bailable.
No, no, it's not small as per the act.
Very small.
Small as per
Yes,
common perception.
Heroin, my lord, let us see.
Not heroin, Lord, it is
Not heroin.
Ganja, my lord.
Ganja, Lord,
Ganja,
only.
my lord.
And nothing to improve here. That has been recovered, sent to FSL, everything has been done. Every
Section
witness has
50
been-
notice.
35 days, Lordship.
Section 50 notice, any notice you have annexed?
No, I am not challenging on those parts, Lordship. Those part is there, but as it is recovered from my residence, so far alleged there. But according to me, it was outside of my house. But they have shown it from my residence.
Section 50 will not lie.
Hmm?
Section 50 is not applicable, Lordship. I am not going on that.
Oh, acha, it's house search, na?
This house search.
House search.
Rather, 42 is not complied with, Lordship.
I pray, my lord, let it be on, my lord, after a week, my lord.
After,
Some investigation.
Schedule
there, my
not involve anything more, Lordship.
It shows this prescribed some
Witnesses have been taken only FSL report, missed at the best.
opportunity has to be given to the, my lord, investigating authority also, my lord. 60 days was mandatory, my lord, 35 days, my lord. Where from that ganja come, where?
And I have no criminal antecedent, Lordship, and I have annexed, Lordship,
It is
on.
not a matter of, my lord, right, my lord, that they will get it.
No, I am-
Even 30 days, my lord.
Lordship, I have
Their
annexed
right
one
arrows
medical
only on
certificate,
60
Lordship,
days.
and birth certificate of my 4-month-old child, Lordship. Page 22 and 23, Lordship. Page 22 is the birth certificate, Lordship. My child, date of birth is 1/4/2026, Lordship,
Hmm.
and he is ailing, Lordship. I've given the medical document, Lordship. There is no one to take care of that child.
The mother is not there.
Mother is there, but she is a rustic rural woman, Lordship.
4 months.
4 months only, baby, Lordship. Only 4 months only.
Not on the
there-
child.
There are
So
children
kindly
outside-
consider it, Lordship.
there are children outside, my lord, who are, my lord.
How quick can you have it?
After a week, my lord, only I am saying, my lord. On third, my lord.
Interim bail may kindly be considered, Lordship, in the event of calling of CD.
No.
No, it's not a right, my lord.
28, can you have it on 28?
28.
Lordship, maybe on 27, 20 times.
27th? Huh? Heard Mr. So-and-so, SK
SK
Podal and a counsel appearing for the petitioner. The. Then you take down from here. Page 1 and 2, 483. Petitioner was arrested on 17/7/2026. Call for the case diary, list again on 28th. 27th of August.
Lordship. Lordship, in 5, Lordship, if your Lordship goes to the FIR at page 17, some omnibus allegations of some cyber crime
Ah,
has been lodged. Some named, actually 10 persons have been named in the FIR,
ah,
and the petitioners are not at all the named
then
persons.
why are you inside?
At 19, Lordship, names of the.
No, why are you
That is
inside?
only political vendetta, Lordship.
Huh?
Political vendetta, Lordship.
Cannot be a matter.
You only have political.
Where
Lordship,
does
may I read
political
the FIR, Lordship,
Your name is
at page 18
Azharul,
onward, Lordship.
Hafiz and Jiarul.
There is a allegation
Zarul.
the syndicate is also exploiting services of local person, etc. It illegally dealing in foreign digital assets. Then page 19, although the number of persons involved to be individuals named
Kindly
below.
read the FIR, my lord.
Specific
It's
has
very,
been
very-
given at page
very, very
19, Lordship.
serious crime, not that, my lord.
Huh?
Simple, my lord. If your lordship goes to very, very serious crime. Not that very simple.
No, they have given the names, Lordship. And
Right.
where none of these 6 petitioners are the named declared, Lordship.
Cannot be
Six,
named
there
always.
there are how many petitioners?
6 petitioners, Lordship.
Cannot be always named, my lord.
Specific names have been given, role have been given to them
After investigation.
in the
they said,
FIR.
Cannot be, my lord.
The individual named below have emerged the active participant in the commission of the aforesaid offences. Specific role have been given. to them.
They are actively participating.
I am not aware there.
All over the, my lord, to the other countries also, my lord. Lordship, can kindly see the fourth
These
para-
10 peoples are there, Lordship. Maybe
fourth
they
para
are.
also.
Ah, 31st. 31st of August. Let them have the CD. Let us see if it is it connects. Call for the case diary, list again on the 31st of August 2026. Hmm.
Somebody was arrested on 8/3/2026, my lord. Commercial for a notice shall go, my. CR may be called for, and in the meantime, my learned friend will give me a complete set, something.
A complete set.
It is complete, yeah, no?
Heard Mr. NNB Chaudhary, learned senior counsel, assisted by
A day.
AD, learned counsel appearing for the petitioner.
Yes.
Mr. RKD Chaudhary, learned learned senior counsel, assisted by Ms. L. Devi, is present for the Union of India, NCB. Call for the scanned copy of the DCR list again on 31st of August.
RB and law.
Scan copy comes.
Only scan copy.
We just send a message and they send a scan.
Can you,
Uh,
September, how about the agreement?
1st September,
2nd September.
2nd September.
Yeah, I come.
Now he would have your markings on that.
I have also marked in some marking.
Yes.
May it please your lordship.
Ah.
Lordship, this is a regular bail application. Here, lordship, violation of section 43(5) is there, lordship. Why I am submitting this, lordship, kindly come to the FIR that is on page 14, lordship. The lady was picked up, lordship, as 5:45 PM and he was brought to the police station on 7 PM, lordship. That after sunset, he has apprehended, lordship. A lady cannot be arrested after sunset, lordship. That as per 43(5), lordship. On that ground, lordship, this petitioner deserved bail, lordship. Because the quantity is little bit than the small quantity, lordship. 1000 gram is small quantity. Here recover 1060 gram ganja from this present petitioner, lordship.
What was the sunset time on that day?
That day, lordship, it was 6:10 PM.
6:10.
Yes, lordship, as per Google, lordship, have searched.
Ah,
And here she was brought to the police station. That is on page 15, lordship, will find. In paragraph 3, after completion of the all due formalities, the police party departed from the place of occurrence at 6:45 PM and arrived in the police station at 7 PM. Along
so
with the
prior to that,
apprehended-
there was interrogation.
that
They were detained prior to
her
that.
liberty has been curtailed. She was not allowed to move anywhere, lordship. She was in police station, lordship.
We'll have
If
to-
the lordship, if the lordship, the 24 hours time is counted, it will be counted from the time when he was apprehended by the police, lordship.
Very well.
Yes, Yes,
Come to page 14.
yes, lordship.
First three, second paragraph from below the names.
Yes,
Read
lordship.
that sentence.
I, along with the available staff, proceed to the place of occurrence 6 PM. And the PO, following the source of information, the team reached the PO at backside of the Sonaram field at 6:05 PM.
Ah,
On reaching the place of the woman was found in the backside of the Sonaram field on the suspected manner.
now stop here for a moment.
Yes, lordship.
She was found at 6:05,
Yes, lordship.
detained 6:05.
Yes, lordship.
We have given orders that if you are detaining at 6:05, the
Lordship.
arrest starts at 6:05.
She came to the police station.
Sunset at 6:10, arrested at 6:07.
Lordship, she came to the police station. That is on page. Kindly.
That is a different thing. The
When
moment
she
you,
was speak to the.
sir, listen to us.
Lordship.
Day before yesterday, we have passed an order.
Yes.
Saying what is an arrest and what is a detention.
Detention.
Detention, arrest, everything we have discussed.
Yes, lordship.
There we have said that
Yes.
as per the Supreme Court, the moment you deprive a person of his liberty to go wherever he likes,
Yes, lordship.
the arrest starts.
Yes.
6:05 you are apprehended,
Yes, lordship.
6:10 is the sunset,
Sunset, lordship.
6:09
But
they have time.
But when he was, but lordship, that calculation, lordship is.
We'll call for the case diary. Let us have the timings.
Lordship, short date, lordship.
Ah, yes.
31st.
So this Bhrolu,
Borough,
31st
lordship,
May.
next week, lordship.
Next week, 31st.
31st. 31st of August.
Because same question raised before the Telangana High Court, lordship, division bench.
Oh, it
There
was
also
raised
the-
before me.
Yes, lordship.
I would be persuading myself more than the Telangana High Court division bench. Will I know?
Only sir, person. High level.
Take down that partner. Application under so and so. Case number so and so. Call for the case diary. List on 31st of August 2026.
May it please your lordship. Lordship,
Yes.
case lordship, case diary may be called for lordship. Commercial quantity, Lordship, 142 days in jail custody.
Heard
Lordship.
Mr. B. Chaudhary, learned counsel appearing for the petitioner, also heard learned MP goes, learned APP. Then you take from page 1, 483, Badarpur PS case number so and so. CD or case diary?
Case diary, my lord.
Case diary.
Case diary.
Charge sheet or case diary? Call for the case diary list again on
14, my lord.
14th of September.
Lordship, it will be too long, Lordship, 142 days in jail custody, Lordship, the rate. While
10th
searching the
of
board.
September.
Yeah.
10th of September.
Item 16.
1/6.
May it please your lordship.
Hmm.
On the other day, your lordship has asked the public prosecutor to produce some document because lordship, here my plea was that I was produced before the remand magistrate because after 24 hours, lordship. So they were supposed to produce when I was produced. Because I have specifically mentioned that my brother was called to the police station at 12 PM, whereas their list was prepared at 8:30 AM on the previous day. And
In the meantime, we have sent a signal on the day before yesterday also, Malad. Till now, I have not received, Malad. Maybe taken after Sunday, I have to inquire in our office, Malad. Something, if not, Malad, then maybe taken. We have sent the signal on 19, Malad.
Huh?
We have sent the signal on 19, Malad.
Okay.
If, maybe taken after some time. Just I'll inquiry, Malad.
You departed at 10:30 on 5/3/2026. And the production was on,
next day.
huh?
Next day. Next day that after in the last part of the day, lordship, because my brother was called to police station at 12 PM.
Just for a clarification, page 23.
Yes.
After completion of all formalities, police party departed from place of occurrence at 10:30 AM. Along with the items and apprehended person. So
Apprehended.
10:30
10:30
AM in the morning at 5/3/2026, he has been taken into. And he was produced when?
On next day, lordship,
On the next day,
Next day.
in the second half.
second half.
Second up that timing, Malad, just.
If it is after. So when? After some time. After some time.
Lovely.
61.
Well, commercial quantity, CD will be required.
Okay. Heard Mr. Didas, learned counsel appearing for the petitioner, also heard the learned APP. The petitioner was arrested on 15/6/2026 in connection with Hubri PS case number 215 of 2026. Registered under section 22C/25 of the NDPS Act. Call for the case diary list again on Hubri.
7th.
Huh?
Could it be on 31st? In first week, I shall not be there in out of station.
7.
Let me take a chance on 31st. If it doesn't
Yes,
come, that is all right.
31st. 31st of
Obliged, much obliged.
Item 9. Motion item 9.
My please, your lordship. This, the petitioner here is the cattle dealer and the seized cattle were his. And they were seized from the vehicle of the arrested accused person who were transporting them from Boko to Dhodara for sale there. And the petitioner has annexed all the receipts through which he has bought the cattle. There is an annex 4, page number 24 onwards. And when the cattle were seized, the arrested accused person fled the place of occurrence, fearing that they may be arrested on illegal cattle transportation.
Ultimately, they were arrested.
The other accused, yes, they were called, they appeared before the police and they were arrested. Now the petitioner hearing is also contacted by the police and he is apprehending that he may be also be arrested. Hence the petition. FIR is at page number 14, your lordship.
Let him appear, give you all the documents, verify the documents, let us know whether they belong to the same cattle or not.
Yes,
Huh?
yes.
You can have your instructions whether it is for these cattle or not. If it is not, lying to the court.
Yes.
Heard Mr.
I'm Sodial.
M.R. Sodial, learned counsel appearing for the petitioner, also heard Mr. K.K. Parashar, learned APP. The petitioner is praying for a pre-arrest bail in connection with Dhukdhara PS case number 43 of 2026 under so and so so and so. Full stop, call for the case diary. List again on 17th of September. 17th of September 2026. The petitioner, who claims to be the owner of the seized cattle and to be in possession of the receipts
Yes, sir.
of the cattle trade,
Purchase.
shall appear before the investigating officer on or before the 3rd of September 2026, full stop. In the event of his arrest prior to the next date of listing, the petitioner shall be released on furnishing a bond of rupees 10,000 with one surety of the like amount to the satisfaction of the investigating authority. Stop. The investigating authority shall inform the learned APP whether the receipts produced by the petitioner relate to the particular cattle seized or not.
Deeply obliged.
Matter will pass for timing, Lordship.
Apparently, he is a disabled person.
Yes, Lordship.
How is he connected to this?
Lordship actually is not being in the affair, but his car,
Huh?
the registration number of the car is similar to what he owns. He owns a Honda I-10, but in the affair it is written as Alto K10. And subsequently, Lordship, there's one notice has been served recently.
This is an AB.
AB, Lordship.
What is this? Why is it an AB? Page 16. Page 16.
Lordship, there is another matter.
The accused is present.
Lordship, it is another matter. We have not hidden any fact. There's one more NDPS case which is going on, where on the basis of the statement of the co-accused, he has been charge sheeted. He was shown as absconder. Thereafter, he appeared before trial court. Now he's facing the trial.
Then how can we consider an AB?
This is a different matter. Lordship, in this matter,
That he would not repeat the offense. How do we overcome
But
that,
Lordship,
sir?
only the Lordship, can I take it to page number 28, Lordship? The FR starts from 28 of this Rota 7 of 26. Lordship. Here, Lordship, the number of the vehicle is S01 DS4845, but it is given Alto. Is only. But I will.
No, you are not changing the car. You are changing the number plate, sir.
Lordship, I will not change the number plate, Lordship. And after 7 months, Lordship, this 67.
You wanted it after some time.
Lordship,
You wanted it after some time.
let it be after some time, Lordship.
Either we call for the case diary.
Lordship, I have not have pressed for the interim, but only because this 67C notice has been given,
Ah.
and I am directed to appear on 20th. The moment I appeared, I apprehend that I may be arrested, Lordship. It has been
You are
given to us
required to appear
as
when?
this AB, Lordship. 23rd, Lordship, this Sunday.
Good.
Commercial quantity, 103.
Lordship, Lordship, I will cooperate, and I have not
There are
written
two
any.
cases pending against you, sir. We are not convinced on an interim.
Lordship,
After some time, let his senior come.
Lordship will find the FIR case 10. The allegation is made
Tell us how this
allegation is made against the.
last 1.5 months ago,
Yes.
unknown perpetrators repeatedly sprayed suspected anesthetic or intoxicating substance. And after that, last 1.5 months ago,
In fact, all these accused persons who are named in the FIR in the last.
you are one of them.
Yes.
You are a third.
All these persons are neighbors of the complainant.
Neighbors.
Neighbors, all the neighbors have been named. Because there was a dispute between the land dispute between the in-laws with the and the complainant. That your lordship will find at page number 10, para number 2. Deepak Bharti and Jonali Bharti physically assaulted us because the husband of the complainant left the complainant, and thereafter they are trying to grab the land and dispute arose between them. And just because
This is from where? Not Gauhati.
not Gauhati, Sangsari police station.
Not good.
Huh?
Huh?
31st? 31st? Or next?
No, tell us two things. One, this lady is saying that my two minor daughters,
Yes.
6 years, 7 years, 17 years, 8 months, we do not know. Then she says that 1.5 months ago, they sprayed things into our house and they committed the act.
By some unknown culprits. And thereafter again she named on out of suspicion.
And everyone in the neighborhood is,
Next week.
huh?
Next
Give
week.
us a date.
27.
27, we'll have it on 27th.
Lordship.
Heard. Mr. Arbora, learned counsel appearing for the petitioner, also heard the learned APP, Mr. KK Parashar, full stop. The learned counsel for the petitioner has drawn attention of this court to the FIR where an allegation has been made that some unknown perpetrators repeatedly, that prior to 1.5 months of lodging of the FIR, some unknown perpetrators had sprayed a suspected anesthetic or intoxicating substance into the residence of the informant and committed severe sexual assault on the informant and minor daughters. Full stop. The learned counsel for the petitioner has submitted that the present applicant is a neighbor of the informant and has been named only on suspicion as would be reflected from the FIR itself. Full stop. He has accordingly paid for an interim protection. Full stop. Noticing that the matter relates to POCSO, issue notice to the respondent number 2. Respondent number 2. In accordance with the prevalent notification, petitioner to take steps during the course of the day. Full stop. List again on 27th.
My lord.
27th of August 2026, enabling the learned APP to have this report on the service of notice on the respondent number 2 and the case diary. We'll have it on 27th.
Lordship. Always good.
May I please, your lordship? Yes, FI that page 14, your lordship. CD may be called for your lordship.
Heard. You are Miss S. Nazneen.
Yes, sir.
Yes. Ask your clerk to not to write Mr. in front of your name.
Okay.
Heard Miss S. Nazneen, learned counsel appearing for the petitioner. Also heard Mr. KK Parashar, learned counsel, learned APP. This is an application under 482, praying for grant of pre-arrest bail in South Salmara PS case number 103 of 2026. Call for the case diary. List again on South Salmara PS is
My lord, on 31st.
31st of August 2026.
Blake.
Yes, sir.
Great, Mr. Lordship. My lord, I am a mason, my lord, Rajmistri, and I have been accused on the statement of a co-accused that regarding my lord pilferage of some cement bags. The Azhar is at page 14.
Your name is?
Dated 15/7, my lord. Lodged by the particular contractor. May I just read out? In the night of 13/7, second pair I am reading, my lord, 13/7/2020 at about 8:30 p.m. local public detained a JCB bearing registration number so and so, carrying 30 bags of topsoil cement from the site. When inquired, JCB driver Azimuddin, son of so and so, informed that accused Hasibul, who is a petitioner, Hasibul is a petitioner, had given him the cement bags. On further inquiry, I have come to know that accused Keramat Ali, so and so, has been receiving stolen items from a construction site. The JCB had recovered cement bags, rupees of Iman handed over to Sukia PS on Iman. Your Lordship will kindly note the dates 14/7. This Azhar was lodged on 15/7, complained of an incident of 13/7. And then, my lord, cement bags were handed over to Sutia PS on 14/7. Now, your lordship will kindly come to see page number Annexure 3, page 17.
Huh?
Now, there, my lord, the place of seizure, has your lordship seen? Sutia PS campus, date and time of seizure on 17/7/2026. So, my lord, we smell some wet, my lord, there. And the co-accused have been arrested and allowed on bail. And their orders are also here, and vehicle also custody, my lord, allowed by the court. Jima is given, my lord. And also the cement. So, and nothing was taken from me, my lord.
Yes, sir, others.
Nothing, my lord.
All recovered cement, Malad.
We'll allow the interim, let him appear.
Let the city, interim, yes.
Interim, we are giving an interim. Heard Mr. B.D. Goswami, learned counsel appearing for the petitioner, also heard the learned APP, Mr. K.K. Parashar, full stop. Application under section 482 in connection with Sutia police case number, Sutia PS case number 73 of 2026, full stop. The learned counsel for the petitioner has submitted that the matter relates to the allegation of theft of around 30 bags of cement from a construction site, and the persons who had been arrested along with the bags of cement, and the person who had received the said bags of cement have also been released on bail by the learned court, full stop. The learned counsel for the petitioner has submitted that the petitioner is working on the construction site, and the police
As a Rajmistri.
as a mason. Full stop. The learned counsel for the petitioner submitted that the petitioner would be willing to participate in the investigation process and cooperate in the same, and false allegations have been leveled against him. Full stop. Call for the case diary list again on the 15th of September 2026. In the meantime, the petitioner shall appear before the investigating officer of the case on or before the 3rd of September 2026. And in the event of the arrest of the petitioner on or before the next date of listing, he shall be released on bail on furnishing a bond of rupees 10,000 with one surety of the like amount to the satisfaction of the arresting authority.
That's obliged.
For anticipated bail application, annexure A, page number 12. So allegation basically theft of vehicle and other materials. One joint Sodhuri lodged an affair with the in charge of GB construction at the project of construction. There must have been such affair.
Is this the, was it rejected earlier?
No, your lordship. Case has been succeeded and I was found as a respondent, therefore
I do remember this case.
notice has been served upon me. Presently, I have filed.
Why do I remember this case? Construction site, electrical equipments, driver of the Bolero informing that some part is missing. Then he is found to be the accused. Is it that story?
In the
Yes.
vehicles,
I remember this story.
Stolen.
Huh?
Yes,
The driver who had informed is found to be the accused.
yes.
Ah, I remember this story. Kindly verify. Huh?
otherwise, now succeeded. Succeeded.
Now charge sheeted, but he says it was not listed before. And no other earlier bill petition was.
First bail
Maybe,
application.
in the, registry might have made an inquiry, in the first phase, of the file, maybe there, Manas Purin Dora.
I might have read in the earlier other bail petition.
Oh, yes.
There was another bail petition for another person on the same affair.
But see, in this case, lordship,
It is now charge sheeted. Why are you before us?
your lordship, if I will appear before the trial court, may apprehension that I will be arrested. Therefore, lordship, protection mechanism is granted to me, lordship. So if I itself clarify that the driver Manas Putim Dwara, myself, who is engaged as a rented bolero camper bearing registration number so-and-so as a driver has informed me over telephone that the bolero campus so-and-so number has been missing from our store yard and also informed that the vehicle has been parked. So I immediately informed to the authority that the vehicle has been police custody lodged. But subsequent stage, FIR has been lodged against me and two other associates. So it is my bounden duty to operate the vehicle being a driver as per instruction of the Mohori as well as the contractor. So I operate only the vehicle. So I am not liable that it is very.
Why did you not participate in the investigation?
So, Your Lordship, at the time of when the vehicle has been seized by the police authority, I was interrogated, but I was subsequently allowed to release, allow me out.
Your statement has been recorded by the police.
No statement has been recorded.
Then
But subsequently,
At
at least liberty may be granted,
Then can December be called for?
protection shall be granted.
Materials may be there.
So I'll be.
either we call for the scan copy of the TC or something.
So, Your Lordship, till then kindly be, protection may kindly be granted.
Protection of what?
Already absconding.
It's a charge sheeted case.
Yes.
Investigating authority is not arresting you.
Now who will arrest?
Court has not given you a summon to appear.
Yes.
Of
call-
what? From what from
Yeah.
what will I protect
call-
you?
Call for a skill.
From what will I protect you?
Yes, call for.
There must be something I can protect you from. Heard Mr. Saikia Learned Counsel, M. Saikia Learned Counsel appearing for the petitioner, also heard the Learned APP. An application under section 482 of the BNSS for the since the petitioner apprehends arrest in connection with Bongaigaon PS case number 292 of 2025, full stop. The Learned APP has submitted that the case has been charge sheeted by charge sheet number. Where do we find it? 292 of 2025, full stop. Although this court does not find any reason for the petitioner to apprehend arrest once the investigation has culminated in a charge sheet, at the request of the Learned Counsel for the petitioner, call for the scan copy of the TCR.
Number.
You should be close it.
Sheet number 62.
Where?
What he has mentioned.
Search sheet number 62 of the 20. It's number 20.
Oh, FIR number 292, I'm sorry. Charge sheet number 62 of 2026 dated 19/5/2026. Yes. You should not be entertaining this.
Look.
No,
Huh?
until and unless an NBW order is there,
I do not know. Anyway, we'll have it on when? 31st of August.
So another day.
Mr. Saikia will be forced to close the petition otherwise.
Look, I will be actually out of station.
No, another day after.
When?
Third.
3rd of September?
Yes, yes.
3rd of.
My lord, we raised bail application, my lord. My lord, FIR at page 19, it's a long FIR, my lord. The basic allegation is, my lord, the
Mule
petitioner,
accounts.
number 1 and 2. They are, my lord, running a registered CSP at Borpeta Road, my lord. And the so-called offense has been happened at Zagi Road, my lord. And the allegation is, my lord, they opened some accounts under the CSP and they siphon the money from the account, my lord. How they open the account, my lord? The persons, they are hailing from Zagi Road under the Zagi Road case, which is 250 kilometers away, my lord. Their CSP is.
Sir, money is siphoned off by opening accounts from beyond international borders.
Who deposited the money in the account?
No, my lord, city without city.
That is not there, my lord. My lord, the person, the informant, they are the president and secretary of some organization.
We can call
The
for the.
persons who are depriving, my lord, they are not come forward, my lord. They,
You are the persons who own
my lord, kindly come to page 19.
Who are you?
I am the, my lord, registered owner of a CSP, both the petitioner. And now, my lord, the informant, they are from, my lord, some organization. The persons who are depriving, they are not come forward, my lord. They did not lodge this FIR, my lord. Kindly see the, my lord, FIR at page, my lord, page 20. One is Hari Prasad Deuri, Secretary Deuri People's Justice Forum. Resident of, my lord,
You are on AB number 1962 of 2026.
1962.
Who is?
Petitioner is, my lord, one is Masuma Khandakar and another is.
Oh, you are
Lukman
saying the FIR informant.
Yes, yes,
Informant.
informant.
Hari Prasad Deuri, Secretary Deuri.
And Pradip Kolita.
We'll have it on 31st with the case
My
diary.
lord, another bail petition, my lord, that is DA, my lord. This is, my lord, CD has been called for, my
When?
lord, on 3rd of September.
3rd of September, list along with
along
BA
with
number.
DA number, my lord, 2393.
List along with BA number
2393.
2393 of 2026 on 3rd of September.
My lord, in the meantime, my lord, for the lady, my lord, she is holding a, my lord, minor child in her lap, my lord. Only for the lady, my lord.
Yes,
Some protection maybe.
or lady perhaps. Will require the lady to appear petition number 1. Where have you said she has got a child?
My lord, at Para, my lord. Later on, I have collected the birth certificate also. My lord, Para 2, my
How
lord.
old child? Child is how old?
My lord, 1 year, 6 months. My lord, Para 2, my lord. I have stated.
Full stop. The learned counsel for list a matter on so and so will the learned counsel for the petitioner has submitted that the petitioner number 1 is a registered is a
CSP.
she is what registered what?
Registered CSP holder.
She is a registered
Owner.
registered CSP holder and is the mother of a 1.5-year-old child. Full stop. It is provided that the petitioner number 1 shall appear before the investigating officer on or before the 25th of August 2026 to participate in and cooperate in the inquiry proceedings. In the event of her arrest, the petitioner number 1 shall be released on bail on furnishing a bond of rupees 10,000 with 2 sureties of the like amount to the satisfaction of the arresting authority. Full stop. The pre-arrest bail has been granted, interim pre-arrest bail has been granted to the petitioner on consideration of that she is a lady with a 1.5-year-old child, and the same would be reconsidered upon perusal of the contents of the city.
Obligement. One more prayer, my please. My lord, one more small prayer, my lord. The name of my junior colleague, my lord, may be shown in the cause list. May be shown in the cause list.
The name of Miss
R.M. Lamin.
Shall be reflected in the cause list as the counsel, as one of the counsels for the petition.
With obligement.
Yes.
My pleasure. In this case, charge sheet is submitted.
Heroin 1.27 grams.
Charge sheet submitted in connection with other case orders, Your Lordship. After filing of the case, Your Lordship, I came to know that such submitted.
You want to approach the trial court? Same order?
Same.
Same FIR?
Same FIR.
Same FIR. Your name?
My name is Hafizul Rahman.
Heard Mr. H. Rahman, learned counsel for the petitioner, also heard.
My name is
Mr.
A.R. Karim, Your Lordship, for the petition.
Heard Mr. A.R. Karim, learned counsel for the petitioner, also heard Mr. K.K. Parashar, learned APP appearing in the matter. The learned APP has submitted that the charge sheet number 712026 dated 11/8/2026 has already been submitted. Full stop. Learned counsel for the petitioner submits that the matter relates intermediate quantity, and he has spent how many days behind bars?
No, no, Lordship, just wait a minute.
Relates to intermediate quantity, full stop. The learned counsel submits that the matter may be, that this bail application may be disposed of, granting liberty to the petitioner to approach the learned trial court as and when the necessity arises. Accordingly, the anticipated bail petition is closed, giving the petitioner the liberty to approach the learned trial court as and when required to do so, to pray for appropriate relief. Yes.
Obliged.
Lordship, this matter is Lordship. Pertaining to
CDA waited.
Transited case.
TCR, yes.
Lordship. Lordship, under section 6 POCSO.
Fenখন এক দুই হাতমান কমাই দিয়কচোন। Slow কৰি দিয়ক, বন্ধ কৰিব, slow কৰি।
Under section 6 POCSO allegation. Transited case, Lordship. And Lordship, I am submitting not on merit, Lordship, only on the ground that the accused person is behind the bar as an under-trial prisoner, Lordship, since 386 day, Lordship, more than 1 year. And Lordship, the prime witnesses, Lordship, the victim's mother, who is the informant, and victim's father has been examined already, Lordship. This, and moreover, Lordship, the accused has believed that the offense has not been committed by him because, and for that reason, he himself, Lordship, filed a petition for DNA profiling also, Lordship. Mainly, Lordship, that as a UTP, Lordship, more than 386 days. And the main, Lordship, the witness.
What is the punishment?
Punishment, Lordship, is more than 20 years, Lordship. And that I admit. That's why I am saying that on merit, I am not, Lordship, having, Lordship. Then, Lordship, total 4 witnesses has been examined, Lordship.
3rd day of November, first witness.
After, Lordship, on witness number 4, PW 4 was examined on, Lordship, November 2024, Lordship. I think thereafter no progress, Lordship. On November 2024.
November 2025. 13th of November 2025.
Oh, I have mentioned today. 2025, Lordship. 8 months more than that. In the evidence, Lordship, I have no good case because the cross part is more weird than the safe part, Lordship. And I have filed for DNA profiling also because I believe that I am Lordship innocent because Lordship, I believe that that may be committed by someone other.
Let the profiling come.
Profiling.
Has it been under?
My instruction is that the victim is not providing the sample for DNA loss. The victim's son, child loss. I have submitted loss.
Yes, madam.
Lordship, in this case, the alleged victim, your Lordship. Lordship, he has accused the accused person of repeated offense of rape, your Lordship. And in the medical also, sperm was not found because it was on much later date, your Lordship. So even though DNA profiling is to be done, your Lordship, finding out whether she was, it will be difficult to find out the spermatozoa, presence of spermatozoa.
DNA profiling doesn't need that, madam. DNA profiling needs the blood of the father, the mother, and the child. Where are you all going otherwise?
That I know, your Lordship, but then medical has not stated anything about the pregnancy. Pregnancy of one eye.
Medical?
Pregnancy of one eye.
After itself,
Single life fetus, 14 weeks, 2 days, plus minus 1 week pregnancy.
Yes.
Are you not prepared, madam? Should we have it after some time?
Subsequently, Lordship, the child was born, Lordship. Subsequently, child has born. And thereafter, I have filed this DNA profiling petition, Lordship, at page 47, Lordship.
We'll call for a report. What has happened to the DNA profiling? Is she refusing? Otherwise, we can reject it now. We can reject it now, but we just want to be doubly sure whether the victim is refusing her DNA or the DNA goes in his favor or it goes against. If there is a DNA report. When?
It will be from the trial.
No, the trial court had already asked for a report
Which has not yet been received.
on 7/3/2026. Trial court কেতিয়ালৈকে আছে চকচোন order বিলাক? Huh?
Report has not been received yet.
Trial court last date to some?
Person case number तुम्हारी है।
Address करके, हाँ, फिर यहाँ से number वगैरह करके, week से। ये सब, यहाँ पे लिखी थी सब paper से।
ये देखो, ये जो केस नंबर है, इस स्पेशल बॉक्स को कोर्ट नाम से इक्वल है। disseminate स्पेशल बॉक्स।
On 27/3, there is an order. Complete the entire exercise within a period of 1 month. 27/3, so that will be 27/3, 28/3. 28/4. Done. Heard Mr. Swenson and counsel paying for the petitioner, also heard Mr. Goswami, learned EPP, and Ms. Das, the learned. You are amicus or respondent number 2?
Amicus, sir.
Learned amicus, full stop. The trial court records reveal that on 27/3/2026, the learned trial court had required the OC of the concerned police station to conduct the DNA profiling test upon the accused and the child of the victim to determine as to whether the accused is the father of the child. Full stop. It was also recorded that the child had been surrendered for adoption under 35 of the JJ Act before the CWC Vishwanath. Full stop. The later orders of the trial court does not reflect as to whether the DNA profiling had been conducted by the concerned OC. And any report had been submitted to the learned trial court. Full stop. Place this matter again on the 7th of September 2026, requiring the full stop. In the meantime, the learned trial court shall send the report regarding the conduct of the DNA profiling test as ordered by the learned trial court on 27/3/2026.
Obliged.
Subject to correction, right? He has also a right to refuse the DNA profile.
We do not know. We want a report. It is his statement that she is refusing.
Yes.
Now the issue is she may refuse. She has surrendered the child for adoption. Would she still retain the authority to refuse a DNA profiling of the child once she has surrendered it? When the question is of a person facing a sentence and a conviction and sentence, she may refuse hers.
And
Once she surrenders the child and she does not bring the child back, within the 2 months period given for reflection. Huh?
Now guardianship.
Just my report will be called.
How we've called for a report from the.
Obliged, Lordship.
Yes. Item?
Wait, please, your lordship.
Yes, sir.
My lord, it's a in-between case, my lord, NDPS, my lord. The lordship may kindly have a look at page 13, my lord, the FIR, my lord.
Yes.
My lord, with reference to subject cited above, I have to honor to inform you that today, 19/7 at about 4:15 PM, an information received from a reliable source. So there was an information that someone is coming with drugs, my lord. Third paragraph, my lord. At around 4:20 PM, I along with the PS reached the Gandhi Bosti railway gate, so and so, my lord. At about 5:25 PM, we intercepted the said scooty bearing registration number so and so along with 3 suspected persons, including 1 woman. On being asked, they introduced themselves as so and so, my lord. 1, 2, Momi Das, Bhaskar Medhi, and Babul Sarkar, my lord. Well, thereafter, my lord, I have approached 2 persons, namely Mahar Ali, my lord, 2 persons, my lord, and requested them to stand as witness, and accordingly they agreed to do so. I have also explained the suspected person for the purpose of search. Accordingly, I have served notice under section 50 NDPS to the suspected person and searched them. The woman was searched by the one WH
Woman Home Guard,
in presence of the independent witness and the inspector Jiten Das. My lord, my case is simple, my lord. On that point, my lord, they were searched personally, my lord, and the investigating team had a tip-off, my lord, that someone is coming, my lord. But they ought to have been ready with the gazetted officer or the magistrate before checking that thing. In the instant case, now if your lordship turns to, my lord, the seizure, my lord, that your lordship will find at page 23, my lord. 23, my lord, lordship will see the witnesses, my lord, all independent witness. So, my lord, section 50 of the NDPS Act says, my lord, if a personal search is made, my lord, so it ought to.
They say there is a 50 notice.
50 notice is there, but the search is to be made before a gazetted officer or a magistrate. It was not done, my lord.
Is it compulsory?
Yes, it is compulsory, my lord. In, my lord, one of the case, my lord, the apex court has held, my lord, there is no third option, my lord.
What are the 2 options?
Magistrate or a gazetted officer. My lord, one of the order of a coordinate bench, my lord, it will be
Yes, Mr. Goswami. Only 2 options.
Again, that thing will come, my lord.
What?
Refusal part.
Huh?
Everything. Section 50, my lord.
Tell us.
Yes, fair enough.
That is what we are asking you.
But
Learned Council
I'm
is
just
saying that there are only
taking
two options. Yes, which period?
My lord, first give a lordship, have a look at the bail application, my lord. Hanif Ali, my lord. That paragraph 4, my lord. It is the contention of the learned counsel for the petitioner that a body search of the petitioner was carried on without complying the provision of section 50 of the NDPS Act. And although recovery was allegedly made from some bags in the possession of the petitioner, since the body search of the petitioner was carried out, compliance with the provision of section 50 of the NDPS Act was mandatory regardless of the fact that no recovery was made from the body of the petitioner. In this regard, this Paramananda. Earlier, my lord, we used to thought that, my lord, if I carry a bag, my lord, and if the contraband is found in the bag, my lord, then 50 notice was not required. But in the Paramananda case, my lord, the Supreme Court has held, my lord, once you make a personal search of me, whether
It
any
is in the
contraband
bag
is
or
found,
wherever it is.
if contraband is found or not, my lord, that is immaterial, my lord. That so it has to be made before the, my lord, magistrate or the gazetted officer, my lord. Then paragraph 9, my lord. And the other one is, my lord, the appeal was allowed, my lord.
Same on the ground?
On that ground, my lord. Judgment to করতে হবে। এটা আছে, এটা আছে। My lord, there may be there may be a, my lord, ground, my lord. If, my lord, a person is going on a train, my lord, suppose I am traveling in a train, my lord. So now there is a suspect, my lord, some contraband is with me. In that case, my lord, the IO may search the person before an independent witness. That is there, my lord. But in the instant case, my lord, they are a tip off. They know there is an information that someone is coming with a scooty with this contraband.
Can he ask for a gazetted officer or magistrate to be near him just because he received the tip off and he'd keep waiting for 24 hours, nobody comes? How does he keep a gazetted officer or magistrate with him all the time?
But he has to take before.
He has a tip of there may be some sale of this thing. It may happen, it may not happen. Would you keep a magistrate or a gazetted officer sitting with him for the entire time he waits there?
When they are apprehended, when they are intercepted,
Yes.
they ought to have been taken before a magistrate.
That is what we are trying to find out.
In a train or a bus, it may happen, my lord.
And in case the arresting authorities of the opinion
My lord.
that taking them there, here, this, that, he
Yes.
might be able to throw
Then
it
a
away. Then
particular-
what happens?
Then a particular note has to be there from the IO in the diary.
Huh? That
Then
is
a
what we would
particular
like.
note has to be there, my lord, in the diary, my lord.
Might be there, we do
My
not
lord,
know.
I have got a 56, my lord. That's,
Of?
50 of NDPS, my lord. Subsection 6, my lord. First, if your lordship has to go 55, my lord. 50 subsection 5 of 50, my lord. When an officer duly authorized under section 43 has reasons to believe it is not possible to take the person to be searched to the nearest gazetted officer or magistrate without possibility of the person to be searched parting with possession of any narcotic drugs or psychotropic substances or controlled substances or articles or documents, he may, instead of taking such person to the nearest gazetted officer or magistrate, proceed to search the person as provided under section 100 of the CRPC. Now, my lord, it is 103 of BNSS. The 6 is important, my lord. After a search is
You will have
conducted,
to make a note and send it to the superior authority.
yes, my lord. After a search is conducted under subsection 5, the officer shall record the reason for such belief which necessitated such search within 72 hours and send a copy to his immediate officer. If he has made that note in the, my lord, diary.
Yes.
Okay.
Is that, my lord, he was offered to search, my lord, he declined, thereafter search was made, my lord. It was offered to search before a gazetted officer, my lord.
Where is it?
My
This
lord,
does not say so.
it is there, my lord, in the
Then again, that question will come in whether he was given that,
option
he
of,
was informed of the right.
or he was given right to reject.
Heard Mr. NJ Dr. Learned Counsel appearing for the petitioner, also heard Mr. MP Goswami Learned APP. The Learned Counsel for the petitioner has submitted that there have been violations during the body search of the petitioners in connection with the recovery of the alleged contraband. And in such circumstances, the petitioners would be entitled for the privilege of a bail. Full stop. Call for the case diary list again.
My diary is here.
Diary is received.
What does it say? Oh,
Because it was.
oh, this is item 1 where the diary has been.
It was listed earlier, my lord.
Now,
my lord.
this section 50 notice.
There was 33 in custody, 30 days, 33 days.
34 days in custody, my lord, in between, my lord.
That
That
is
is-
that
what
is
about the rest
the
of it?
recovery was made from them, my lord.
From his
He has
side.
made just 2 arguments.
Yes,
50 notice,
And-
was it given?
yes, 15.
Was it given?
It was informed of his right, my lord. So, but that was, my lord, he has denied it. That is one.
That 50 notice, if you show us,
15 notice is not in the diary, my lord. He was, that nothing is there, my lord, that he was given the option to research before a gazetted officer, but he denied it.
was he given the information,
thing
he
is
has the
absent,
right to refuse to be searched?
That thing is absent.
So from where will you get it? Okay, call for the case diary to cut off. Learned counsel for the petitioner has also drawn attention of this court to the noting in the FIR that that the arresting authority had served a notice under section 50 of the NDPS Act upon the such suspected persons and searched them within bracket the female co-accused, being searched by a woman home guard. The learned counsel has submitted that since the petitioner, since the informant oblique arresting authority had previous knowledge of, or had proceeded for the arrest after a tip-off, the absence of a gazetted officer or a magistrate in this case would vitiate the body search, and therefore the petitioners would be entitled to the privilege of bail. Full stop. The learned counsel has further submitted that in case a body search is made under the provisions of section 50 within bracket 5 of the NDPS, the provisions of section 50 within bracket 6 would come into play.
Yes.
And there is nothing on record to show that the arresting authority had complied with the same. Full stop. The case diary has been received, and Mr. Goswami, MP Goswami, learned counsel, learned APP appearing for the state, has gone through the same and has submitted that the case diary does not contain a copy of the section 15 of the notice under section 50 of the NDPS being served upon the petitioners herein. Full stop. The case diary also does not contain the record where the arresting authority had sent the had complied with the provisions of section 50 within bracket 6 of the
It is
NDPS.
there, my lord, that he was given the option of search, my lord, but that may be.
Learned counsel for the petitioner for the
I
learned
recommend-
APP has submitted that the case diary reveals that the petitioner had been given the option of
Search before a.
search before a gazetted
Applying.
officer, which was
which was
refused
denied.
by the petitioners. Full stop. Anything else?
Other things, recovery was made by from the.
The learned the learned APP has submitted that
Conscious
substantial
possession.
quantity has been recovered from the petitioners,
From the pant of the petitioner number 1.
from the pant of the petitioner number 1. Anything recovered from the petitioner number 2? The lady.
These two are present, my lord.
Huh?
From them, joint possession, my lord.
Eh, on a body search, you find something from joint possession, they cannot be wearing the same pant at the same time. Huh?
Covered from them, my lord. Yes.
How can they be wearing the same dress at the same time? Two persons. No. Stop.
Another thing like regarding the maid, I like to submit, my lord, they stated that they came there to sell the vials to one person who contacted them.
The learned APP has submitted that as per the investigation conducted so far, the petitioners have,
They are peddlers, my lord.
huh?
They are peddlers, my lord. They
The
came to
petitioners have confessed to being peddlers who had come to that area to sell the material to the seized material to some other customers. What you'd like to call for the section 50 notice, or should we proceed on the basis of the case diary? We'll proceed.
That, my lord, at least one opportunity till. my
But
lord.
you had it, you did not ask for it. You have not asked for it.
Because.
Should I prompt you?
No, because.
Should the case diary not contain that?
It should contain.
It is a partial case diary.
It should contain. Then, my lord,
The petitioners
Tuesday,
have
my lord.
already, the petitioners have already been under custody for 34 days as submitted by the learned counsel for the petitioner, and the prayer of the learned APP at this stage to call for further documents, comma, in the opinion of this court cannot be granted at this stage, since the matter relates to the personal liberty of the arrested persons, full stop. It would be prudent upon the investigating prosecuting authority to furnish complete documents to the learned APP to render his duty before the court. Stop. In the given facts and circumstances of the case, I am of the considered opinion that the body search of the petitioners have been rendered illegal. And therefore, in the absence of due compliance of the provisions of section 50 of the NDPS Act, comma, the petitioners are entitled to be released on bail. Full stop. Accordingly, the prayer for bail is allowed. It is directed that the petitioners, namely so and so shall be released on bail on each furnishing a bond of rupees 1 lakh with 50,000 bail bond of rupees 50,000 with 2 local sureties of the like amount, comma, one of them each being a government servant, to the satisfaction of the
Chief
Special NDPS.
Special NDPS, Kamrup Metro.
special judge, comma, NDPS Kamrup Metro. Stop. The petitioners has not been charged sheeted.
Not, sir.
The petitioners shall continue to participate and cooperate with the investigation as and when required to do so by the investigating authority. Stop. The observations made are confined to the instant bail application and shall have no bearing in any of the proceedings.
I'm
Bail
obliged.
applications allowed
I'm obliged, my lord, deeply obliged.
to the extent indicated above.
Another case, my since my learned senior friend is there, item 26, man. CD is there, man. I am praying fixing on Tuesday, man. 26.
My only point, my lord, 26, let him be, he will argue, my lord. In that case, my lord, there are 175 soap boxes of heroin, my lord. And what the magistrate, my lord, before sampling, my lord, they mixed it, my lord, homogeneous. Whether that can be done or not. Let him reply to that effect on Tuesday, my lord.
Yes. At the request of the learned APP, list this matter again on 25th of August 2022.
My lord, I'm obliged.
Please, your lordship.
Yes.
Has already been addressed by my brother. Here, lordship, what has happened, lordship?
The only thing that is that we are not getting to appreciate is the second occasion.
I understand, Lordship, but Lordship may also kindly consider my bona fideness, Lordship. Now, Lordship, what will happen? I have not concealed anything. I have admittedly written down that there is a pendency of a case against me. Now, Lordship will kindly see that that vehicle was not in my custody when it was given, because
Could not have, you are the owner of the vehicle.
I'm the owner of the vehicle. But
Mr. Goswami, tell us one thing. He's a person with eyesight disability.
No, sir.
He owns a vehicle. How far do you think he could be responsible for where the vehicle is being taken, by whom it is being taken?
That we cannot say, my lord, because he may be innocent, may also, my lord. With his knowledge, sometimes, my lord, this transportation is going on, my lord. That is very much, my lord, possible, my lord.
no, I have no, so far this case is concerned, Lordship, I have no knowledge, because I have stated very specifically, this vehicle was being used by my driver. And my
It's a commercial registration. Someone else is using the vehicle.
no,
Commercial quantity.
no,
No,
it's not commercial vehicle, it is a private vehicle. Now, quantity is commercial, that is why I'm apprehending, Lordship. It is a private vehicle, I have given it, because of my blindness, I have given it to my driver. Now my driver has given it to rent to somebody else without my consent. And after that, I came to know that my driver is lodged in the jail. When I obtained a certified copy, Lordship, of the FIR, I found that my vehicle is involved. So far this case is concerned, I am nowhere involved, Lordship. So for the other case is concerned, that is there. And Lordship will kindly appreciate that 7 months the vehicle was lying there with the prosecution. They never tried to give me any notice. After I filed a bail petition, I have received a notice under 67C. Now, to appear before the IO on 23rd, Lordship, it is fixed on, and that is eventually a Sunday. So my apprehension, Lordship, the moment I appear, I may be arrested. So my bail application will become infected.
What is the name of your driver?
His name is Ambrose Doimari. AMBROSH Doimari. Ambrose Doimari. I have stated it, Lordship, in my petition. I have stated it. Para 3, page 3, I have stated everything regarding.
Where is the FIR?
FIR is in page, Lordship, will find 17.
Huh?
No. I'm sorry, Lordship. Just a moment.
No, we were shown some
28, Lordship. Kindly see.
some discrepancy in the description of the vehicle.
Page 28, Lordship, may kindly have a look, Lordship. There, I am a owner of a vehicle Hyundai i10. There they have written it Alto i10.
We are not interested in that, sir. The number plate can be changed anytime.
No, number plate is this. This is my number plate, Lordship. Admittedly, this is my number plate. AS0 and DS4845. Now, this number plate may be used in some Alto, I don't know. That is, your Lordship is correctly saying. That part I don't know. Lordship, my only limited prayer, I understand, Lordship, it's an NDPS case.
Yes, sir. On two factors. One, that the vehicle which is registered under AA01 DS4845 at page 13 is a Hyundai Motors. Yes. And secondly, that he is suffering from this blindness. He would appear before you on Sunday, 23rd, to have his statement recorded.
It's a commercial quantity, madam. That is why regarding the whether he has knowledge or not, as I have said it earlier, subject to correction, my lord. That there are also judgments in that line, my lord.
He was not apprehended with the vehicle.
Yes, he may be not apprehended.
Now,
one thing.
Now, no. Clarify us on what we have doubts, then we'll listen to you also. We have always listened, we'll listen to everybody. Suppose the vehicle that I keep using, the number is put on some other vehicle. This is apparently what has happened. You have described it as an Alto I-10.
I-10.
Alto I-10?
Alto I-10 cannot be my lord.
It should be Alto, maybe Alto K10. I don't know what it is.
No,
written
it
down.
also, it's also maybe a Hyundai I-10. Maybe a Hyundai I-10. It's I-10.
Registration number.
What were you saying?
Registration number.
What were you saying?
Just I'm saying, my lord, if he is, my lord, guilty of with the knowledge that he has, that transportation is being done with this, then he will not be, my lord, entitled for Jimma also, my lord. That is what the regarding honorable court has said, my lord. Because for that, my lord, whether he is entitled for
No,
Jimma.
what we had in mind is he would appear before you on the 23rd, record his statement, find out what is required. Also have your instructions on this Alto I-10, which car.
Sure, I have got.
The front side would have been the Maruti and the back side can be an I-10, no.
Lordship, I have got one document, Lordship. If I may
How do you
kindly.
describe an Alto I-10?
Lordship, can I place one document before Lordship? This is the order of the magistrate where this vehicle was produced. It is one Alto vehicle registration number so and so without key. Lordship, may kindly able.
Alto vehicle.
Alto vehicle. That was produced before the.
So the, this
Magistrate.
thing has been used.
And the registration number is my registration number. Alto without key, they are saying.
But then your name cropping up in two cases.
Two cases, my lord. One is, my lord, suscited
So far this,
already, my lord.
so far this case is concerned, Lordship.
37 says
I
you would not repeat.
I understand.
You have repeated.
No,
What
Lordship, my submission, Lordship, may kindly have a look into it, Lordship.
I'm trying
That-
to.
That in the present case, Lordship, I have no role at all. In the one which is charge sheeted, that's a different issue altogether.
That will come to light once things proceed.
Yes,
Now, if you appear before the IO,
I have a apprehension, Lordship.
if you appear before the IO with the
I will appear,
with
Lordship.
your documents that that vehicle number
Lordship.
is a Hyundai i10 and this is not a Hyundai i10, would he still proceed to arrest you?
Maybe, Lordship. That is why I am
No.
praying, Lordship, some protection may kindly be granted to me, Lord. Only one line, Lordship, no coercive measures may be taken against me,
Lord,
Lord.
may kindly say page 22, my lord.
Huh?
The page 22 is very much revealed, my lord.
Yes, this man.
That earlier case, my lord.
No, no, that too.
Vehicle is used twice, my lord. He knows that, my lord. So
That also, Lordship, it is a matter of trial.
that will
The
matter
place-
of trial.
Trial. Because
But
that also we do
knowingly
not
that-
know.
knowingly
Can I
that-
submit little bit? Lordship, there is a charge sheet where my name is there, surfacing. Prima facie, there is a charge sheet. But then from the trial, it will come out whether I was.
And that vehicle must be still in custody, that I10 vehicle.
Lordship, may kindly say, yes. The first sheet was filed on, my lord.
No.
Earlier first sheet regarding this vehicle, my lord, involvement of vehicle, it is on 24.
Hmm.
And now it is, my lord, 26, my lord. He has earlier also, this vehicle was involved. So now also, my lord. So
How can
section
Lordship,
37, my lord.
if that
says
that
that, my
vehicle
lord.
is in custody, how I can use that vehicle again? That means somebody is using my number plate, Lordship, without my knowledge.
Without or with your knowledge is the only issue. Your name comes cropping up every time.
Yes, ma'am.
And that's
Right.
what I'm saying, Lordship will kindly see that I'm a handicap, Lordship,
It's 45%, I've seen.
45%.
It is not 50%. It is 45%.
Only my only.
What is
submission-
your usual profession?
I'm a farmer, Lordship. Lordship, my only submission before Lordship, very limited submission, Lordship. Let me appear, Lordship, before the IO on 23rd, Lordship, with all my documents, with everything. Only thing I may kindly be protected, Lordship. There no coercive measures may be taken against me. If there is something in the case, there
Repeat
is-
offense.
if there is something,
When there is a chance of a repeat offense, your name keeps cropping up, we are not interested.
if there is something, Lordship, then definitely that protection will go.
Even considering the interim, we have to look into it whether you would have.
That is why, Lordship,
have
I'm
an
not
effect.
pressing for an interim now. I'm just pressing then no coercive measure may kindly be taken. Otherwise, my bail petition will become infructuous, Lordship.
You would not appear if there is no coercive action.
No, I will appear, Lordship. I'll certainly appear with.
Then what
due course.
coercive action requires to be taken? You would say that your vehicle, that 4845 is an item which is already in the police station, I am not involved. Why would they arrest you?
There are apprehensions, Lordship.
Why? Apprehension, that apprehension is in
This
every
notice
case.
is there.
That apprehension is in every notice, is it not? Anybody who's called to participate.
But here in this case, Lordship, I am not at all involved, Lordship.
I can call for the CD at the best.
Lord,
When?
first week
Yes, sir, when, huh?
first week of September.
Because of the heard Mr. A. Bhattacharya, Learned Counsel appearing for the petitioner. Also heard Mr. MP Goswami, Learned APP, full stop. The Learned Counsel. Should we record anything? No. I think we'll simply call for the CD.
Right.
Our recording may influence otherwise. Call for the case diary list again on the 3rd of September.
3rd of September. Okay. 4th can be.
Court is closed, my 7, my lord.
No, 7 will be delayed.
2nd, 3rd or 7th?
3rd.
3rd of September.
Diploma.
27.
Yes.
I pay for passport for time.
Huh?
Timing.
Why?
They go what of will looking.
Why? I thought we could hear you.
Showcase ready for disposal. PCR received. Informant appeared. After something.
After some time.
Diploma.
28.
Yes.
May I please, Your Lordship?
Hmm.
Lord, kindly see the order dated 27/7/26, whereby I have
27/7/26. Ah.
whereby granted interim bail, my lord. The
Hmm.
petitioner already released from the custody, my lord.
Hmm.
And it by that order, PM report was called for.
My lord, today's CD was called for, the CD was sent back, my lord. Thereafter, we have not received it back, my lord. So, date may be given, my lord. Since the CD was sent back, he was granted the interim, my lord.
Yes, ma'am.
Should we record anything more than what was recorded in the order dated 27/7/2026?
Simply say CD.
Should I read out the order? Therefore, due to the fault of the IO in not submitting the necessary documents,
Yes.
the petitioner cannot be detained and is afforded the bail.
Yes.
This is what we did a few minutes ago.
Yes. It is not.
At any condition, I am paying for absolute.
Ah,
I love the kindly fix a date for the CD, man. That is my.
the order dated 27/7/2026, while granting bail to the interim bail to the petitioner, had recorded that the said bail that the sale bid had been granted due to the fault of the IO in not submitting the necessary documents, due to which the petitioner could not be detained indefinitely. Full stop. The updated CD had been called for today. No. Full stop. The learned APP prays for further date. List again on
11th, 11th September.
11th of September 2026. Full stop. Learned APP shall bring the earlier order and today's order to the notice of the concerned SP of the to the SP of the concerned district.
Interim order, my lord.
The interim order passed earlier continues.
Diploma.
29. May I please, Your Lordship?
He was arrested on 12/6, my lord, and within time, my lord, charge sheet is submitted, my lord.
Ah.
Honorable Court called for the case diary, and last occasion, the learned people informed that already charge sheet date, and scan copy was called for, my lord. Perhaps scan copy has come. My lord, time submitting, my lord, since already charge sheet date, my lord, and police searched the house, my lord, here. So section 50 also not comply here. So I am praying, my lord, that case is suscited and intermediate quantity, my lord, 71 days, he will face the trial, my lord. Under any terms, condition, maybe give you opportunity to face the open trial, my lord. It is not the commercial quantity, my lord. A opportunity may be given, my lord, to face open trial, my lord. Because so that he can collect his defense also, my lord. 71 days, my lord.
Commercial quantity.
No, my lord. Intermediate, my lord. Only 1 kg, 32 gram ganja was recovered.
Per head 1 kilo 32 grams in every case. Be a lot of
That's right, my lord.
contrabands roaming in the market.
Yes. Ganja, my lord. Under any terms condition, my lord, he will face the trial, my lord. Already he is in jail, my lord.
Acha, on the FIR, I'm just.
My lord, it was recorded, although my land council. has
How
taken-
small a house it is?
House, my lord, house.
How small a house is it?
My lord.
We don't know. 1 kilo and something recovered from the house.
My lord, from the house of the.
Will that suffice? The bed, the table, the floor, the almirah, the top of the almirah, upon the fan, in the bathroom, inside the cistern. Where?
My lord.
I enter the house and I find 1 kilo ganja smiling at me on the sofa set. Hmm? During the course of search, one white bag was
My
found
lord, white
containing ganja.
bag containing so and so was recovered. It is
Containing ganja, yes.
My
It
lord.
was smiling at him from the sofa set, dining set. Where?
It is not mentioned, but it is from his
And the
house,
man is
my lord.
behind bars.
From the FIR, it reveals, my lord, from his house, my lord.
In the
Recovered-
entirety of his house.
My lord.
Yes, what do you say? He's saying,
My lord, he's
let
saying,
him
but
face
my
open
lord,
trial.
search framed on, my lord, on 18/8, my lord.
Few days ago.
Search frame under section, same section, my lord, and 2926 for evidence, my lord. Let some of the witnesses be examined, my lord.
Yes, sir.
Well, it will take some more time because here.
How many witnesses?
Total witness, my lord, here.
7, my lord. 7 witnesses.
Seven
my lord.
witnesses, my lord.
At least seizure witnesses may be examined.
Take more than one
From
year,
that,
my
it
lord.
will be
Within
clear.
1 year also not complete, my lord.
Huh?
Because
You approach the trial court once.
maybe grant, my lord,
Approach the
because
trial court once. Then we'll allow you.
this court also can grant, my lord. In so many cases,
We
the honorable court
we
grant,
are
my lord.
unable to convince ourselves that that 1 kilo was for your consumption.
If, my lord, it is not, it is, would have been.
When you're on 300, 400 grams, maybe up to a kilo.
But charge also framed already, my lord. The charge
And-
order I have, my lord. I have collected the charge. So I
You
am
approach
praying,
the
my
trial
lord,
court
that
once, sir.
anyway, he will face the trial, my lord. May consider, my lord.
Approach the trial court once. It is intermediate quantity, they may allow.
My lord.
Charge sheeted case, usually we are sending it back.
My lord.
And once they come back, we try to consider it.
Then at least some witnesses also.
Something is done till that point of time.
71 days. sir.
71 days only.
60 days was the statutory period, but before time, my lord.
So when they're up and doing,
My lord. After session, I
This
have
is
no
not
other
a
ground, my lord, to
formula,
pray
but-
before the honorable court.
Huh?
Only after session, there is a prima facie case. I have no other
you
ground to
approach the
pray.
trial court once, sir.
Only I am praying, my lord, the honorable court may consider, my lord, because in so many cases, my lord, this court also allow, my lord, but I.
We'll make all the observations we can, but you have to approach the trial court, sir.
Right.
We are not doing it here. We have not done it in other cases also. But Mr. Swensol and the counsel appearing for the petitioner. The learned APP has submitted that the charge sheet has been submitted in the present matter.
Scan copy also.
And a scanned copy of this, scanned copy of the TCR has also been received, full stop. The charges have been framed on 18/8/2026
8, my lord.
and the case, and the matter is listed next
29
before the learned trial court on 2/9, full stop.
for evidence.
The learned counsel for the petitioner has submitted that the petitioner, that the recovery of the petition from the house of the petitioner is only an intermediate quantity, slightly being above the 1 kg. benchmark, and the petitioner has already suffered 71 days in custody, full stop. In view of the fact that the charge sheet has been submitted and the charges have been framed, we deem it proper that the petitioner should approach the learned trial court to pray for grant of regular bail at the present stage, full stop. Accordingly, the bail petition, this bail application is closed, allowing the petitioner to approach the learned trial court to pray for regular bail. Bail application. I have recorded whatever I could. Any more submissions? I'll record that also.
Not dismissed, my lord.
Hmm?
Not dismissed, my lord, only closed, my lord.
We are closing it, allowing you to approach
Yes.
once. Approach once.
I will ask.
You want. 31 is what?
May please your lordship.
My lord, here CD not received. my
Lordship,
lord,
I am praying for time limit.
Here CD not received.
The CD has not been received.
Commercial quantity,
Commercial quantity. CD first called on
my lord.
26
My lord.
2026. 26/6.
6 my lord.
2 months. How much more?
My lord. Next week, my lord, any date, my lord.
The case diary had been called for on 26/6/2026. Today on 21/8/2026. The
Second, my lord.
learned APP, huh?
Second of,
The learned APP has again sought for time, full stop. List again on the 2nd of September 2026. Stop. The investigating officer shall will not make an
My lord.
observation now, but
this is the commercial.
now we'll start making observations. Have your CDs ready? Can you keep them behind bars?
Here, requisition also sent to the, in several occasions, my lord,
So
from our office. also.
Because we are appreciating your efforts, sir, we are asking the IOs to be now informed or the SPs to be informed.
My lord.
We are appreciating the effort on your part.
We have from our office also requisition.
That is why in some cases I am saying not today. I am not issuing strictures today. But this will not be allowed. Yes, next. 40? 33. 33 X my from key hole.
May I please your lordship?
Hmm?
Charge sheeted case, my lord.
Huh?
PCR has been called for and.
Here, ganja was recovered 10 kg, my lord, more than 10 kg, my lord, from his post, my lord.
12.46.
Only third sheet submitted, my lord, and here cognizance taken on 14/8, my lord. And next date was already over 19/8/26 for production and copy.
26?
19/8/26
Ah.
for production and copy.
And
Why don't you
here-
try there?
My lord, there is delay in production before the magistrate. He has not produced within 24 hours.
Go and show it to the trial court. Why don't you show it to the trial
My
court?
lord.
Huh? They are not empowered to give you the bail on that ground.
Lordship,
Yes, what time were you arrested?
my lord, kindly see the page number 17, the seizure list.
Hmm?
Seizure list. Physical custody was taken, my lord, on 21/6/2026, 11:52 a.m.
Page 18.
Page 17.
17, yes. 11:52 AM, 21/6.
Lordship.
And
And he was produced, my lord, I have given the certificate copy, my lord, on 22/6/26 at 2:15 p.m.
yes, sir. Seizure at 11:52 AM, 21/6.
My lord.
Hopefully with the persons. After reaching so and so, we intercepted a scooty.
My lord.
So the seizure has to be at that part of that part. Yes. Page 13. You departed on 21/6/2026 at 12. Last paragraph.
My lord.
And he has given me a certified copy saying at 2:15 PM delivered by UBC so and so.
After
You'd like to go through it?
my lord.
2 o'clock?
Not today, my lord.
Huh?
Not today, my lord.
Today. Small issue. Since when are you in custody?
So we can adopt on the same day, my lord.
With quite some quantity of ganja.
My lord, 10 kgs of ganja.
10 kg
From a scooty, my lord.
from the
And
scooty.
10 kgs in a scooty.
My lord. 2 packets are there, and from the witnesses, Caesar witness, my lord, the civil that he is doing the business, my lord. He is doing the business for a long time, my lord.
We'll have it on Monday. Today we'll have to get up at 3:30. We do not know whether we'll. Learned Counsel appearing for the your name, sir?
H. Ahmed.
H. Ahmed, Learned Counsel appearing for the petitioner has submitted that it would be apparent from the records that the petitioner had been arrested arrested before. Now again see page 11, sir.
11.
Page 11. Occurrence of the offense Sunday 21/6 at
9 a.m. Here 9 a.m. Here after, my lord,
then at 12 o'clock you come back, huh?
11.
That the petitioners had been produced before the learned remand magistrate after the window of 24 hours granted by law had elapsed, and therefore the arrest of the petitioner and further detention have been rendered illegal. Stop. The learned APP seeks some time to go through the records. Stop. List the matter again on 24th of August 2026. 24th. A certified copy from Grady Divo. Give him a copy of this order. It will help him. Yes, sir.
Yes, Your Lordship, CD was called for.
Huh?
And today is 189 days. I'm behind the bar.
189 days
Yes.
by tomorrow. Yes.
Yes,
Same number?
34.
189 days, sir.
My lord. That's it, submitted, my lord.
When? When? Would you like to go back or should I call for the
Your Lordship may call for it.
scan copy?
Yes, Your Lordship.
Otherwise, what is your ground?
I am the driver of a truck cargo vehicle.
Ah.
I was transporting goods.
Ah.
And if Your Lordship turns to page number 19B,
Ah.
I was transporting the cough syrup for some period firm or private limited. I was not aware what was inside the cargo. I was just I am the driver. And during the NACA checking, the contrabands were seized from the vehicle. That's my point on this. Your Lordship.
But you are not supposed to know what is in the cargo.
Yeah, they have seal envelopes. Challan were given to me. I was carrying. The police also seized those envelopes. So I was not literally aware about it.
My lord, here, charge sheet submitted, let him appear.
Vicarious liability or something like that does not come in criminal law, does it?
Yes,
If it is in your vehicle, it is your something like that.
Yes, Your Lordship.
Transporters will not know what is there in their vehicle. The learned APP has submitted that the charge sheet has been submitted via CS number.
Oh, Lordship, my lord. I charge sheet number 165 of 25,
Dated
dated 10/8/26.
Okay, verify and give it to them. Huh?
My lord.
Verify and give it to them.
Yes.
Verify the number. 25 CD.
Charge sheet number 165 of 26, dated 10/8/26.
26. Call for the scan copy of the TCR list again. on 11th of September.
TCR.
Deeply.
TCR.
Scan copy of TCR.
The petitioner is charge sheeted under section 366A IPC, read with section 4 of POCSO Act. Lordship is behind the bar almost 1 year as on date, Lordship.
What has been said?
Lordship, on page 19, vernacular part of the FIR.
And the daughter went somewhere and she was taken away by the aunt and the accused. Yes?
Yes, Lordship, but 164 is contradicts the FIR. In 164, Lordship, page number 28.
Just a minute.
My father lodged this case.
Page
28, Lordship.
28. What is it, page 25?
25 is the bail order, Lordship. He got bail in 2018 in Gauhati High Court.
For which case?
This one is this matter is a matter of 2018.
Earlier got
Fire
bail,
is the-
Earlier got bail,
subsequently
but,
because of NBW was again arrested.
again arrested on the strength of NBWA. Lordship. He was absent. His subsequent court
Jump bail.
proceedings.
Trial was delayed Malad because he was absent Malad all these years Malad.
From 21 to
Hmm?
25.
21 to 25, 4
He
years
was
he remained absent.
21 to
25.
2025.
4 years. You did
Because
not
of
attend the
was
trial.
delayed, Malad. And
First
after-
part is the COVID period, 21. Then his father died, lost his father, and he was the only bread earner, Lordship. And he was a resident of Golaghat. And the case proceeding is Lakhimpur Special Court, Lordship. And due to his extreme economic condition, he was absent, Lordship. Three witnesses has been examined, Lordship, out of 7.
The victim has been examined.
Yes, Lordship.
victim examine,
In PW2.
PW2 or informant also examine. On merit Malad there are materials Malad. 183 clearly implicated Malad.
She has not been kidnapped from Lakhimpur, Lordship. On 13th of February 2018 at 7 a.m., she went to Tezpur without informing her parents and her auntie, and the accused petitioner was waiting for her at Tezpur. As per 164 in page number 28, then she said, we went to his house situated at Golaghat. On second day, we got married and wear vermilion. And third night, we live as husband and wife, Lordship.
But to that, regarding that Malad, she in the evidence SPW2 has mentioned Malad, as per the version of the Malad, mother of the accused, she has deposed in the 164 statement, like that Malad. As per the, as per
Read a
the
few
Malad.
lines before that.
Malad.
The Tabiz was making her do everything. Have you not read that line? The Tabiz was making her do everything.
But as caused by Malad.
She was reckless then, and now she has come to senses. Yes, what guarantee do we have? What guarantee do we have that you will attend the trial? This is on merit of the case. This is on whether you will attend the trial or not. Just tell us. Yes, during this last 5 years, any hampering and tempering by him? No.
No, no, Lordship.
We'll allow it. Heard Miss
And Hudson, Lordship.
Learned
Legal
Counsel
aid.
appearing for the petitioner and Hassan, Learned Counsel appearing for the petitioner, also heard Mr. K.K. Parashar, Learned PP, and Ms. T. Parashar appointed amicus to defend the interest of the respondent number 2, since none had appeared. The petitioner had been earlier granted bail in connection with North Lakhimpur PS case number 174 of 2018. However, on the registration of the special POCSO case number 47 of 2018, the petitioner had failed to appear and participate in the trial, and therefore he had been arrested on the strength of the non-bailable warrants of arrest issued by the learned trial court. On when were you arrested?
20th August of 2025, Lordship.
On 28 August.
No, 20th August.
20 August 2025. And the petitioner has been in custody since that date, full stop. The learned counsel for the petitioner has submitted that the petitioner could not initially participate in the trial proceedings due to the COVID pandemic, and later on because his father had expired and he was facing extreme penury. Full stop. The learned counsel has submitted that the petitioner would now further. Who was cross-examining the? Oh, achha, this is after your arrest. Okay. The learned counsel for the petitioner has submitted that the petitioner undertakes to participate in the trial court proceedings throughout. In the event he is granted the privilege of a bail by this court, full stop. The learned APP has submitted that the absence of the petitioner for 4 years need not be condoned, and he be maintained in custody to ensure his presence during the trial proceedings, full stop. The learned amicus has submitted that the deposition of the informant and the victim have been recorded in the learned trial court.
Another, yes.
And the absence of the petitioner from the trial had apparently delayed the trial proceedings for more than 4 years, full stop. I have considered level submissions. And in the given facts and circumstances, I am of the view that the continued custody of the petitioner, who was earlier granted bail by this court, would not be necessary in the event appropriate conditions are imposed for him to participate in the rest of the trial proceedings, full stop. Accordingly, the petitioner shall be released on bail on furnishing a bond of rupees. Tell us. Since you are saying he's in penury. 25, what was the earlier amount? 20,000, 18. Okay. 25,000 with 2 sureties of the like amount to the satisfaction of the learned trial court. The learned trial court shall be at liberty to impose such other conditions as may be necessary to ensure the participation of the petitioner in the trial proceedings, full stop. The absence of it is provided that the unaccounted for absence on the part of the petitioner in the trial proceedings at any stage may lead to cancellation of the bail granted.
Like not.
Yes, so that when he is produced, nowadays, these all these are online. After charge sheet, all are online. Now I have talked to the OC, he has given me the photo photograph on mobile, my lord. As per the video entry on 6/3 at about 2:30 PM. Run from PS to production, my lord, for production.
Sent
At 2
at 2 PM,
30 PM.
2:30 PM on 6/3. And he was arrested at on 5/3
10:30
morning half.
Morning.
10:30.
So what to do? 4 hours gone.
If at all, my lord, run from the PS at 10 AM.
At 10 AM, I would have considered it. It is traffic.
10:30 AM, my lord, yes.
And then it is traffic. I would have considered your heard. Mr. A. Ahmed, learned counsel appearing for the petitioner, also heard Mr. K.K. Parashar, learned counsel, learned APP, full stop. The learned counsel for the petitioner has submitted that the petitioner had been apprehended. Where was that noting?
That page 14, Lordship.
Apprehended prior to 10:30 AM on 5/3/2026. And he was produced before the learned remand magistrate on
6/3.
he was learned. He was produced before the learned remand magistrate after the window of 24 hours granted by law had elapsed. Full stop. The learned APP on instructions from the investigating / arresting authority has submitted that as per records maintained, the petitioner had been forwarded from the police station for production at 2:30 PM on 6/3/2026. Full stop. He has further submitted that commercial quantity.
Lordship.
That commercial quantity of contraband had been recovered from the petitioner, and in such view of the matter, the bail petition of the petitioner may not be considered at this stage. Full stop. The learned counsel for the petitioner has submitted that the arrest and detention of the petitioner having been rendered illegal due to the delayed production, the petitioner would be entitled to the privilege of bail. Full stop. Having considered the rival submissions and also having regard to the relevant provisions of law, I find that the petitioner, who was admittedly detained prior to 10:30 AM on 5/3/2026, had been sent for production before the learned remand magistrate only at 2:30 PM on 6/3/2026, and therefore the arrest and detention of the petitioner on and after 24 hours of him being detained has been rendered illegal. In view of the above, the petitioner is found entitled to be released on bail. However, imposing strict conditions to ensure his further participation in the trial proceedings. Charge sheet has been submitted, na?
Lordship, submitted.
On
Ah.
29/5/20.
The petitioner was originally arrested on
5/3/2026.
5/3/2026. Oh, that is already there. You cut out that sentence. Accordingly, the petitioner shall be released on bail on you're from the same district?
Same district.
Shall be released on furnishing a bond of rupees 50,000 with two local sureties of the like amount, one of whom shall be a government servant, to the satisfaction of the learned trial court. Full stop. The learned trial court shall be at liberty to impose such other conditions as may be deemed necessary to ensure the participation of the petitioner during the trial proceedings. Full stop. It is made clear that in the event the petitioner is found to be engaged in similar activities or violates any terms and conditions of the bail granted, comma, the prosecution would be at liberty to bring the same to notice and pray for cancellation of bail.
That case number will be mentioned.
Trial court, the trial court adjudicating
Special
DPS.
DPS case number 52 of 2025. 26. 52 of 2026.
52 of 2026.
নহলে সেইটো একদম ওপৰত application under 483 praying for bail কৰি পেলাই হেতাটো কেছ নম্বৰ দি দিব পাৰে। Yes.
Sthiti not received.
44 days in custody, Madam. 44 days in custody, intermediate quantity.
Yes, sir. Intermediate. 34 days. 44 days.
Next week, Malad, if not, Malad, then Malad.
List again on 25th of August 2026. Tuesday, huh?
Malad.
On the prayer of the learned APP to be afforded one more opportunity to produce the CD.
Okay.
The petitioner has already completed 44 days in custody. Yes.
The recovery of 1.521 kg of heroin. The petitioner is basically he is a auto rickshaw owner who earns his livelihood by driving the auto. And the person who was sitting in the rear seat, from him the bag was recovered. And some in the bag there was some soap cases. And he also produced some other soap cases from behind the seat, Lordship will see that page 17, last paragraph, that on search of the said three-wheeler, vehicle commenced at 9:50 AM on 17/4/26. During search of said three-wheeler, it was found that Ainuddin Lashkar was in the driver's seat, that is the petitioner, and Abdul Qadir Lashkar was found sitting in the rear seat of the said vehicle. One black color airbag was found at the rear seat of the said vehicle, along with which said Abdul Qadir Lashkar was sitting. On asking Abdul Qadir Lashkar open the said bag, multiple rectangular shaped plastic soap cases were found inside the said bag. Each soap cases were secured with a rubber band. On opening each soap case, one transparent polythene pouch containing light orange color powdery substance was recovered. When questioned, both Ainuddin Lashkar and Abdul Qadir Lashkar admitted that the light orange color substance was heroin. Abdul Qadir Lashkar took out another 22 rectangular shaped plastic soap cases from behind the rear seat of the vehicle and handed over to me. So it's basically from him, Abdul Qadir Lashkar, this recovery is made, My case is that I was just it's my regular job, to carry people, and I was carrying him, and that apart, Lordship may kindly see, at page 14. The samples reflected, again are, this is, the prayer for production, the accused and endorsement of these articles. Oversee drawal of samples in triplicate, original samples, duplicate samples, or represent samples, seized packets containing methamphetamine tablets, marked as P1 to P7.
It started with heroin and has reached tablets.
My lord, this is what then again they say heroin.
Yes.
Then Lordship will again see independent witnesses, page Panchnama, page 16.
16.
My lord. On 17/4/26, about 8:40 AM, I, along with NCB team, reached Kandigram and mounted surveillance. As per secret information, I requested local persons to act independent witness in case of seizure. In case a seizure was effected, 2 men so and so volunteered to be witnesses. Accordingly, they were listed as independent witnesses. The information available with the NCB team was shared with the witnesses. So, my lord, all these things are premeditated, my lord. Secondly, further, my lord, Lordship will also see the 147 notice. It doesn't give a detail. It says recovery from conscious possession. Now, conscious possession is a matter of judicial inference, my lord. The page 23, my lord. That 17/4/26 Narcotic Control Bureau so and so from your conscious possession seize so and so heroin from your conscious possession at Kandigram near so and so. In this regard, NCB Gauhati case number so and so has been registered. Full details of the seizure as mentioned in the Panchama has been read and explained to you. So, my lord, the details are not given how this seizure, how this was seized, my contrabands were seized. Again, in 48, my lord. Notice under 48, my lord.
Where is it?
Page 26.
26,
my lord. It says, first paragraph, your husband, namely so-and-so, was involved in trafficking of the said drugs. Hereby, in this regard, you are here informed that your husband, namely so-and-so, was arrested on so-and-so 17 hours. Now, it's a 17 hours is shown, my lord, at South Barak Guest House, Barak so-and-so place, for violating Section 8 of the NDPS Act. Therefore, he is liable to be punished. Now, my lordship will see your husband, Abdul Qadir Lashkar, will be produced with the Honorable CJM Lakhipur Kachat. Abdul Qadir Lashkar. His husband is Ainuddin, my lord. The other person is Abdul Qadir Lashkar, my lord.
Okay. Okay. I hope this is not like the Meghalaya case where that one simple typographical error will not change the nature of the notice. Because earlier it is said Ainuddin Lashkar. She knows
It's same, but then this information will be correctly given, well, because first of all, they have to say as per 1 section 48, which place he's been kept, where he has been kept, my lord. That's very specific, my lord. Section 48. And the details of the offense has to be given under section 147 also, my lord. It's simply not saying, but just saying that conscious possession is not sufficient, my lord. The fact, my lord, that this was recovered from, my lord, the other person's, my lord, bag, which was near to him, and he was the one who, my lord, took out the other things from the, my lord, behind the, my lord, seat, my lord. These things are not narrated in, my lord, neither in the section 47 nor in the 48, my lord. Section 48, my lord, says every police officer or the person making arrest under this Sanhita shall forthwith give information regarding such arrest and place where such person is being held to any of his relatives, friends, or any such other persons as been disclosed or nominated by the arrested person for the purpose of giving such information. So, my lord, here, there is nothing to mention where her husband was kept, my lord. And it says Abdul Qadir Lashkar will be, my lord, produced, my lord. So all this, my lord, and lordship will see the independent witnesses. These are basically stock witnesses, kind of stock witnesses, my lord. We were earlier told what is there in the information, etc., etc. So everything was, my lord, beforehand known to them. And it's almost, it's 135 days, my lord.
Yes, sir.
Lordship will allow me to file my objection because from the submissions made by my learned friend is okay, but he does not appear to be a same because I appeared in another case of the same person.
Order?
I appeared in another case where the same person is involved, same heroine. So it is not a case that he is a saint. Lordship will allow me.
This Ainuddin Lashkar is a repeat offender.
In this case.
I do not know both the persons.
No, repeat offender would mean something else.
No, that's a different. No, I mean, whether he had filed another bail, that's what I'm saying.
Not in this case.
Okay.
He is involved in some other case. That is why I'm saying repeat offender.
That may be different.
So, Lordship will allow me some time to file my objections, and in the meantime, Lordship, perhaps the TCR ought to have been called for, but
The CD had been called for.
TCR will be called for.
Otherwise, how do you connect this man to the?
No.
Where is that 48 notice?
48 notice, lordship will find it page, my lord, my lord, page 26, my lord, annexure 6.
26.
Annexure 26 is the
Page
48
20.
notice
Page 20.
signed by the thumb impression of the brother. Yes?
No, brother, yes, my lord, there are two signs, my lord.
And the top one is also one of the brothers.
Brother, my lord. Who is the,
And-
my lord?
And the affidavit has been sworn by him.
Yes.
So 48 notice, they know the actual grounds.
No, these are true, my lord, but then that was served. Now he has come before lordship, my lord. These are all certified copies which have been obtained. But that's what I'm trying to say, impress, my lord, is that this notice doesn't say where is, first of all, is kept, my lord, and that that her husband will be produced. So that much, my lord. That's true, my lord. That so far as the other parts are concerned, Ainuddin has been named. But so far the remaining parts are concerned, my lord, first of all, my lord, as under section 48, they have to inform where the petitioner has been kept kept, my lord, and number one. And number two, the fact that this ought to have been the husband.
We will call for the scan copy of the TCR for the time being. Allow him to file the objection. By when, sir?
Okay, allow me to.
11th of September.
That's fine with me.
11th of September.
It was only yesterday, like I went through the petition. Suddenly I remember, no, I appeared in another case.
It happened to me today morning. There were two accused on the same case. I had gone through the FIR for the other accused, and I was pretty sure that I have read this FIR, and this man has come again without telling me that he was in his bail had been rejected or whatever earlier.
I just checked up the father's name and the spellings. Somewhere here there.
That we allow in the FT also. That we are allowing spellings here and there don't matter. Heard Mr. M. Learned, senior advocate, assisted by. Also heard Mr. R.K.D. Chaudhary, Learned senior counsel, assisted by LDB, appearing for the Union of India in the Department of NCB. The learned senior, Mr. Chaudhary, learned senior counsel, has prayed for an opportunity to the respondents to file their response to the present bill petition. This court also notices that the case diary had been called for by the earlier order, although the scan copy of the TCR would be necessary for adjudication of the matter. So accordingly, list this matter again on 11th of September 2026, by which time the respondents would be at liberty to file their objections, if any, to the bail petition. Full stop. The scan copy of the TCR would also be called for. Will the scan copy of the TCR be also called for?
Deputy Appellate Judge.
38.
May I please, your lordship. Lordship, POCSO section 4, when the petitioner has been under custody 241 days, your lordship. And your lordship, the informant has filed an NOC, no objection, before the trial court in granting bail to the petitioner. That was also rejected, lordship. And
Age of the victim?
My lordship, may kindly please office note 19-8, my lord.
19?
8, my lord.
That lordship, mistakenly a copy was taken, served that on that office, but properly not taken, the steps, lordship.
What not proper? What is improper? What part is improper? Tell us.
No, I have not properly taken, lordship.
Unless the respondent number 2 appears.
That is lordship.
The office note dated 19/8/2026 reflects that the steps for issuance of notice on respondent number 2 had not been received by the registry. Full stop. Let a counsel for the petitioner prays for an opportunity to take steps on the respondent number 2 allowed. List again on what? 14th of September, along with service report.
Lordship. Obligable.
39.
May I please, your lordship.
Yes, sir.
Lordship, case diary was called for in this matter.
59.
Well, here charge sheet submitted.
Yes, sir.
So kindly LCR may be called for. Lordship.
The learned APP has submitted that that a charge sheet has been submitted by charge sheet number
133 of 26, dated 28/7/26.
full stop. Call for the scan copy of the TCR list again on
Lordship, TCR will be coming from special the Spoxo Lokhimpur, Lordship.
11th of September.
Lordship, kindly, Lordship, short date maybe.
We have got 2 holidays in between. We have got 2
Right.
Sundays in between.
Lordship, kindly on 31st or 1st of September.
31st. Okay. 31st of August.
Deeply.
Where is the FIR?
The FIR is on. Type copy is on page 9, Lordship, and
Page 9.
yes, sir. No?
এটা আৰু মাতি ল'ব পাৰে।
41. Deeply. My lord, here also charge sheet submitted, man.
CM will call. The learned APP has submitted that the investigation has culminated in charge sheet number
136 of 26, dated 31/7.
Mr. PJ Soikel and its senior counsel is present for the petitioner assisted by
Emano.
Or for the scan copy of the TCR list again on 7th. 7th of September. Diok, I'll wait for this. Full utilize.
My lord, meter may be taken away 2 months.
Come back at 2.
My lord.
Yes. Your objections are on record now. That's all. No issues. Yes, yes. Let us see.
Yes.
Yes, sir.
Lord, as I submitted in the morning, the petitioner happens to be the project director here of the under National Highway Authority of India, working in Ceylon. So a complaint was lodged by an individual who was a contractor.
This
Yeah.
particular petitioner, he was not involved in the trap case. Others were trapped. When he came down to attend some other official business, then he was arrested. Is that so, madam? No, okay.
So, my lord, what I will beg to submit is that allegation has been made against me, but then they laid a trap also. According to that, in the telephonic conversation, they say that my voice is there, subject to proof, of course, in trial. And but then recovery was made from another person, 4 lakhs rupees, and he was also arrested. Both of them were arrested, and they were enlarged on bail by this honorable court. And now, I am not here in this station. Even 4 days prior to the laying the trap, I was transferred out. I demitted my office and I shifted to Rajasthan,
Page 37.
Page 37. Lordship will find. And I joined there. And therefrom I came back here to attend the contempt case against me, which is pending here in this honorable court. Then I was caught. And now it is the 52nd day. I am in custody. My lord, presumably, and Lordship will appreciate that when they have done the investigation in a planned way, let me take it that everything against me. Let me presume it. They have laid a trap. There was a preparation for that from before. And after collecting all other necessary materials, incriminating materials surrounding the circumstances or attending the circumstances, the incident, they have already taken care of all that. They have collected all that. And thereafter they arrested me. Now it is the 52nd day. I am in custody. Kindly see, my lord. I may reveal this, that till today, within this 52 days, he was never asked a single question by any officer. He was not interrogated. At least once till today. And if they have collected everything, it is in their hand.
After his arrest, he was sent to judicial custody.
Yes, he was sent to judicial custody. I am there. I am languishing. They have not taken care of. That means they have every materials against me. They are satisfied enough. Then I am to face the trial. What purpose will be served keeping him inside the jail now? This is the 52nd day. And I am not supposed to jump the bail also because I am a government official holding a responsible post. I am the project director of the NHCY, National Highway Authority of India. Therefore, my lord, the conditions which were imposed earlier by this court in the other two, Lordship may think that such conditions may be there. I will abide by it. But then question is whether his further detention is at all required. They have not prayed for any further detention also. There was nothing of that sort before the authorities. He is languishing now in judicial custody. Therefore, in my responsible submission, he needs to be enlarged on bail. Page 35, Lordship will kindly see. I have stated that in the last paragraph that he was arrested on 1st July 2026. And on 2nd July 2026, the other accused persons on 2nd July, and the investigation of the case is at a crucial stage. Further, considering the
Whether he was arrested first or the other persons?
other persons, when I landed up here, I was arrested.
When?
On 1st of July 2026. Huh? Sorry, 2nd July. 2nd July.
There is one shortcoming in the entire bail petition. I have tried to go through it again and again.
Yeah.
I could not notice the date of arrest.
Date of arrest? Para 4.
That is at page 12. It is said the arrest of the petitioner at 100 hours, 100 hours night. Oh, no. 100 hours. He was arrested at the night at 100 hours. Huh? Page 12? Did the arrest of the petitioner at about 100 hours?
1 p.m.
100 hours would be 0000 is night 12 o'clock.
Yes, that should be 1 p.m. 1 p.m.
So it would have
epsilon. Yes.
1300 hours.
And they were arrested on 1st of July. I was arrested on 2nd of July. The other two accused persons were arrested on 1st of July. And at any rate,
when were you produced before the remand magistrate?
He was produced On 2nd August, sir, they say in Shillong. Then they.
The specific, the
Second July.
specific statement is that he was not produced before the, he did not have a transit remand.
No, they say, what I find from the order, the other side has said now, let me take the other side view. They said on the same day, he was produced before the magistrate there. And then he got a tangent bail, sorry, he was then shifted here. But we say that nothing of that sort had happened.
Directly brought to Gauhati.
We were straightway brought to here, Gauhati. We were straightway brought to Gauhati and we were never produced before the jurisdictional magistrate there in Shillong. Date of arrest, 2/7/2026. Now, this has been corrected 1 PM, 1.00 hours. From room number 6, officers, mess, chief engineers, lordship has seen that the memo arrest. Lordship may see this, my lord. Certified copies here. This one. You want FIR copy? FIR copy is there, my lord. FIR is here. That's a one. Yes, 21. Forwarding. FIR is page 21, my lord.
Yes. Just a minute.
He is the person, Natabuddin Ahmed, who was the contractor. So he alleges that his bills have not been released. So that is reason why the bills were not released. And now, since I am already out from this jurisdiction, I have nothing to do. I do not have any access now to the papers here, and they have all taken. I think all papers have been taken to the custody of the investigation officer. Therefore, there is nothing left.
Yes, madam. Huh? For most of us, madam. For most of us. Yes.
Of course, they have applied it has been transferred. Before this on. I'm coming to the conversation instead of going to in his conversation, he himself said that he has been transferred. I'm coming to the this objection, our paragraph number 2, we should begin the total picture of the case. Paragraph number 2, I think super and in the most of the time in the phone call conversation, which has been recorded, said for spectrography, and it is also identified, this conversation is here. Now he is taking this money as a demand that already. Paragraph 2, Anand Singh Chauhan is a project.
We are more concerned with the further custody of the person concerned.
is also not there.
Hmm.
In the chance. So they can approach before the trial court below where all the records are there. And they are the influential person. They have the access. He's taking the money through Havana. That fact has been revealed through their conversation itself.
You were reading paragraph of?
Our
No, so far as you are, you have a prima facie view of the guilt of the petitioner according to your investigation. All done. The more you say has been investigated and already recovered and revealed, the lesser is the requirement for a further custodial interrogation. How do you say there are number of officers? Huh? This is the second project director, and there's the third also. Oh, was he? Are you connecting? Are you connecting him to the other project directors at all?
This is not one instance. Definitely it is going economic comments.
Then
These are the equipment involved. Now we want to unearth the person who and other persons are involved in this process. That has been going.
how is his further detention? Huh. How does 52 days of custodial interrogation not reveal what would be revealed in the next 5 or 6 days?
All the contractors and everyone.
Coercing of witnesses, destruction of electronic evidence, and collusion with the principal accused are general in nature and can be taken care of by imposing appropriate conditions in the event of grant of bail. That is what the earlier order says. Cannot be ever. Cannot be ever. There will be never any watertight compartment.
And coming to the conversation, which is reflecting all the details of the case. Should I start?
Which says that now I have left the post, so I will not be able to clear your bills, but so and so will help you. That part. Achha.
How to go through. And give some time to go through.
Yes. Hmm.
You know, and to process the bill of the company for payment of the balance amount of 13 crores on audit. However, he did not process the bill for payment, and Mohammed Teluguddin and he is the contractor, personally made him several times and requested for the payment of the balance. He also sent a several letter to Sri Anand Singh Chauhan on his service. He is the complainant your law. Teluguddin said Anand Singh Chauhan was demanding from him as a right to process the outstanding bill of rupees so and so. See, Anand Singh Chauhan categorically told that unless and until the right amount of rupees 12 lakh is paid, he would not process the bill. He has sent image of the note of rupees 10 denomination. Paragraph number 3. They are giving this on affidavit. He has given the denomination note for payment of the amount to Jaipur under Havana. Nomination of hearing number so and so from his mobile number so and so. Two mobile numbers so and so belong to the complainant through WhatsApp direction to send the amount to Jaipur through Havana channel. And Sri Anand Singh Chauhan has also provided a contact number of so and so of one Meena. This has to be still Anand. As a contact person at Jaipur for receiving the right amount of rupees so and so. On 16/6, the Anand Singh Chauhan has informed Mohammed Teluguddin and he would come to Khanapara at around 5:15 p.m. and instructed Teluguddin Ahmed to give an amount of rupees 4 lakhs as a part of the right amount of rupees 12 lakhs in advance. Teluguddin Ahmed did not want to give any right to say Anand Singh Chauhan project. Therefore, he lost it.
complaint with the CBI for taking a legal action against the Anand Singh Chauhan project manager. Now, to ascertain the genuineness of the allegation level in the complaint, a verification was carried out by the CBI on 16/6/26 in presence of the independent witnesses. During the course of verification, the accused director, the complainant via WhatsApp call to deliver an advance amount of ₹4 lakhs to designated middleman mobile number so and so. The said conversation was recorded using PVR. The delivery, however, did not materialize, and the verification proceeding was called off on that day, waiting for the next move for the accused side. Since the case of the accused was not processed by the accused, the complainant again met the accused petitioner in his office at Shillong, and CBI teams in the presence of independent witnesses entrusted the complainant with India for recording the conversation that was supposed to take place between the accused and the complainant at the time of meeting. During the meeting, the accused had demanded the complainant as to why he was talking too much over the phone on 16/6. 16/6 conversation is here, Lordship. This conversation is recorded with the independent witness. That is at page number 53. This one. I'm coming to that, all conversation. These are the pre-verification of the complaint. 16/6. All these are of 16/6. And discussion about the transaction, this matter are separate and it should not be discussed much over phone. He reached with the demand of right and instructed the complainant to hand over the part of the right amount of rupees so in advance to Puneet. Now Puneet is come in the picture because he was not. The accused has sent the date and the mobile number of Puneet to the complainant to WhatsApp. Here are the messages. The above mentioned fact establishes clear demand for right and deliberate access with multiple middlemen and making a strong prima facie case against the accused and his access of middlemen on the basis of the said complaint, together with finding of the subsequent verification, the FIR bearing number so and so has been amended, was registered against the petitioner Dixon's group. Now the FIR is again registered against the Puneet and some unknown. One Joy is in the picture. Initially, the project director said you give it to the Joy. Joy then deputed to Puneet. Puneet deputed to Manish, his employee, who received the money, and there was a trap. The trap was laid on 1/7/26 in the presence of the independent witness. During which the complainant refused to hammer contact Puneet. Puneet redirected accountability to another person, Manish, his employee. For handing over the right amount, Manish was caught red-handed while accepting the right of the so and so at the instruction of his boss, Puneet, who facilitated and acted as a middleman, pending on behalf of the accused petitioner. After tapping, there was a control call has been made by the CBI person to Puneet that he has received the amount, and subsequently control call has also been made by the complainant to project director. And complainant said, I have handed over the amount to so and so. With regard to the control call, there is a on post tax memo, there is a in the last page I'm coming to that one. Subsequently, I am collaborating the tax screen. Control call. With regard to control call, plots it page number 11, people come. In my office. Here now on instruction of the other side, here no IOS. Complainant Mohammed Nathalabuddin Ahmad made a WhatsApp call from his mobile number to mobile number so and so of Sri Anand Chauhan. This is a control call. Project director Naha Shillong, and the conversation so here is recorded in the memory card inserted in the media. The conversation so here is listened by all.
Madam,
including
we are constrained a little bit today because 3:13 the court has to rise. Show us something in the entire affidavit, in the objection, or a stage where you say that this is why the custody beyond this 52 days is necessary.
How many days are left?
No, tell us why you need further custody of the person, madam. Why do you need to keep him You are there for the purposes of investigation. You are there for the purpose of investigation.
Judgments, all the latest judgment, with regard to the parity, my first number of judgment which I have annexed there is, and Devendra Kumar Bansal is also there. First one is Sagar's case, that is with regard to the parity, that parity cannot be granted. Now.
All right, no parity then.
Devendra Kumar Bansal, wherein the economic offences are viewed as a very seriously. And the that is number 10.
Para. Para 10 is a definition of criminal misconduct by a public servant. Very well. And in this case, the bill had been rejected because it involved a PC Act. Yes? Cases are in, yes, we have seen that. We have quoted that with approval in many cases. Tell us that the bill was rejected here, the petition is.
So it covers this.
That was an anticipatory bill. This was anticipatory bill. Anticipatory bill. Where? Then this is High Court of Punjab. Where? Page
All with regard to the economic offences.
15.
Devendra Kumar Bansal. Every country feels a constant problem for administration and the corruption.
We assure you, madam, you do, there would be no requirement to impress upon us the effects of corruption in the society. We completely agree to it. Now at page 17. At page 17, if you see, para 34. What does it say?
Since shall be considered on its own merit without influence in any manner by any of the observations made by this court, as this court has considered whether the petition deserves to be granted anticipatory or not.
Yes. Now, in that particular case where all this has been discussed, the anticipatory bail petition was rejected. And the apex court said that if this man moves for a regular bail petition, none of what we have observed should be considered. You consider it on its own merits, yes? So now for this particular petitioner, why should we have those observations influence our decision on the merits of the bail? Therefore, repeatedly we are asking you, tell us the requirement of further custodial interrogation, number one, or that what are the things that he may influence, which we will not record, I assure you. What are the further things that he may influence, which the others in the earlier bail petition could not have influenced if released on bail? To keep someone behind bars during investigation, initial 30 days, 45 days, yes. The investigation is on. The CD is good enough, religion. You have got around 8 days left. 52 days now, 8 days left. What more would you want from him during custodial interrogation, which you could not have in 52 days? Bail is something where we cannot consider Madam, on the last occasion, when the matter was adjourned only on the ground that the copy had not been given, when the written objections had been prepared and filed, when there was a time gap of around from 11 to 21/8, not having the CD ready to oppose the bail, there was no order from us to. You want to resist the bail petition. You are to be armed. Is it for us to say that please arm yourself, please arm the PP or please arm the other PPs? Today we have passed orders for the state of Assam also. We had to grant a bail because an interim protection was granted. CD was called for 4 occasions. We have asked the matter to be placed before the Superintendent of Police, to be brought to the notice of the other, that we are granting bail only in the absence of CD. But here is a case where you have everything, on hand to file this written objection. You are not telling us. You are telling us that the CD would be relevant. The CD had to be before you. You are the prosecutor. Would the written objection be filed without a CD? And this is not in this particular case, madam. We want this message to go. We want this message to go to every person who is resisting a bail, to resist it properly, to every party who resists it. Do it properly. Do not depend on us to give you a date. We may be very overwhelmed by the amount involved, by the nature of the allegations made. We may be overwhelmed by everything, but then we have to keep in mind whether the further custodial interrogation is necessary or not. It is not being shown to us.
It's not the issue with the process because it is on the head of the motion, and we are on the stage of filing the process in this objection.
We are talking of a person's liberty, where there are directions that it should not be for a second more. And then someone is kept behind bars, let it be on motion, let there be an order for CD, let there be for this, let there be that, and we drag it on. Bail petitions are considered. Bail petitions are considered on their own merits, madam. Are we to consider bail petitions on a general concept? Not a happy picture.
Case number 74, you have
It's 52.
we have tried to bring all and the record. One Jai Saxena is also involved, so it has to be investigated.
Which Jai Saxena is now? This Jai Saxena is, what is this? Yes, you are showing us the judgments. You are showing us the judgments.
He's also. Page 9. Taking in view the totality of facts and circumstances discussed here, the court is not inclined to grant particularly to the petitioner at this stage, and the petition according to this time dismissed. However, the court is conscious of the fact that it cannot be taken custody for an indefinite period, as that would infringe his right to, but also that the investigating agency owes a duty to the state to complete the investigation of the case. With very respect, within a reasonable time, therefore it is mandatory that the investigation be completed within 3 months thereafter. So seek his release on bail. This is all on economic offenses. And page number 10 says the petitioner is accused of serious economic offenses. And the investigation of the case is and this case has also like the one case Jagan Mohan Reddy's case, which is a landmark judgment the consequence number 10. At page number 10, in support of the contention, he has relied upon the Supreme Court judgment. For against Jagan Mohan Reddy, Center investigation. Even the Prasad and Center of investigation to continue that the economic offenses.
You are reading page 10. We'll read that. We will read that. Now we do not have time to read every paragraph. It will be difficult. Which of the judgments you actually want to rely upon? You tell us that. Shakti Bhog.
Case 3. Vikram Singh Nadu.
Page? The Punjab and Haryana. Seen that. On that you are reading page 10 and page 11. Yes, I read that. Then
And Tarun Kumar.
era number 20.
Need to be visited depend on the number of days. The economic offenses having need to be conspiracy and involving a huge loss of fossil fund need to be viewed seriously and considered as a great offenses affecting the economy of the country as a whole and thereby posing a serious threat to the country's health of the country. Undoubtedly.
Yes, seen that. Read it. I read it. 23. Okay. Yes. We are not concerned whether they have verified or not. Okay.
Serious fraud and investigation of the office. This is Page 24, para 19. Again, here also, the Supreme Court has dealt with various Jagan Mohan Reddy versus so and so. Economic offenses constitute a graph of mass and
Madam, this is the paragraph which was referred to in the earlier judgment. The same thing is repeated here. We will not go through that. We have less time.
Now I am coming. Case 7. That is my son Vitan Kumar Singh was rejected. On the first instance, it was rejected by his honorable court, and he is also the project director of the NAHA. Case number 7, Your Honor.
Okay.
From our honorable courts. He is also the project director. It's rejected. He was also licensing more than 60 years also.
There it was a case where the person was himself receiving the money, if I'm reading correctly at para 12. Okay. We are.
Has been recorded. He said that you pay 4 lakhs and subsequently 8 lakhs.
And what about the next one? This Pushpajit.
So then subsequently, page number 78 of the answer.
The telephone conversation we have seen. Yes. Okay.
Suspect.
Everything.
Okay.
Okay.
He's saying about the Jaipur at page number 8.
And what about the last judgment you have given? This Pushpajit Purkayasta something?
Paragraph 30, 31. They are also regular days.
Okay. ठीक है.
Not a bad thing, because charging is going to be compromised. You have to unwrap the Kavada.
Yes, sir.
Let the all said and done, I will respectfully submit that your lordship has pointed out that this is after all for consideration of bail. We are not entering into merit. That's why I opened my argument saying that presuming that everything is against me, they have laid a trap, they have collected all materials. The collateral bench, while granting bail to the other two accused, has noted, lordship may kindly look into that also. That aspect was also noted in that order at paragraph 7. The arrest, lordship got it, my lord? 7. The arrest of the petitioners have been made pursuant to a trap operation.
We have read it, sir.
Yes.
I'm sorry to cut you short, but we have to get up at 3:15. We have got some matters pending. Therefore, we are cutting it short, not reading out the whole of it. Yes.
I am just pointing out. Therefore, lordship has rightly pointed out that 52 days of detention, and their contention is that why you cannot wait for another 8 days, your 60 days will be completed and you will be out. That is the point asked. Can it be a ground? Can it be a ground? You even you cannot unjustifiably deny the liberty to a person even for a single hour. So therefore, the vital thing is that there is the offense allegations vis-a-vis the constitutional right. This has to prevail, my lord, ultimately. My responsible submission, conditions, if imposed, that will take care of if further anything is there. And it's a robust organization, CBI. Even so many CBI officers are also found to be corrupt and arrested.
This counter allegation, when they say that you are very powerful and you say they are very robust, I'm liking that.
Exactly, my lord. Now,
both appreciating the other.
And I am also in the government. And at all, I think of from a very other point of view, why should I only go for 4 lakhs? If I can ask at least 14 lakhs, if not 4 crores, question is there. Why should I just waste my stomach with a loose motion by eating some leftovers? It is like that.
Something like Shikamari Hat Gudra.
Yes, Shikamari Hat Gudra, and my lord, this is otherwise in Assam is called food khai pet nosto kora.
That was on a lighter note, sir.
Exactly. That lighter note, my lord. I am grateful.
We'll consider it. You will have the orders after we.
Yes, I leave it to you.
After we attend the. It great idiot. You'll have the orders by evening.
Yes. Deeply.
Any other judgment you would like to rely upon, sir? Any other judgment you'd like to rely upon?
Well, we have
except this one, this Puneet Agarwal.
Yes.
I have been given Puneet Agarwal.
Para 9.
Para 8, 7, 8, and 9. I'll consider. Yes.
Yes. We have in our application mentioned para 10. Para 10
of
about bail application. Two judgments, and there lordship might see that one 2023 for SCC paragraph 23 maybe I have noted it. Here this is exactly similar on facts. No, it no. Your lordship will see this is 3 judges bench 2015-10 SCC 152.
That is a page.
At page 152, 2015-10 SCC.
No. Have you mentioned that judgment anywhere here in the
Page 9, para 10. Page 9,
page 9, para 10? Okay.
Paragraph 22-23.
Judgment whether it is still subsisting.
Yes.
Now it
I think
is Supreme Court.
3 judges bench.
Satyanarayan Murthy.
Neeraj Datta. Okay.
Yes.
We'll pass orders in the chamber.
All right.
Disposed of.
Oh,
কোনকেইটা item বাকি আছে লিখি দি দিয়কচোন কাগজখন কোনকেইটা item বাকি আছে yes
May I please, Lordship? Lordship, the case of Foxo, Lordship.
27 series awaited
Lordship, is your
scan TCR has arrived yes
accused is behind bar, Lordship, 24 months, 14 months, Lordship,
14 months
14 months, the aged person, Lordship. Informant is his daughter-in-law. Victim is Lordship.
The accused is around
Can-
68 years old man, my lord, related, my lord, grandfather. And victim is around 5 years old, my lord, student of class 1. And my lord may peruse her state, PW is PW2 evidence. And
Sir, introduction
183, almost similar, my lord.
introduction এখন
Record. PW2, till now, my lord, 4 witness already examined, 6 only.
yes sir not the proper stage I think
Lordship, almost all witnesses are complete.
Could be, could
Official witnesses.
6.
could be but looking at the proximity of the
Some facts are there, Lordship. If we peruse the FIR and also statement of PWD3 and PWD4.
Only IO is left, my lord. Out of 7, 6 examined. So not in the complete. In fact, in, 6 years.
6 years.
PW2
Comprehensive FIR.
Recorded up to 4 or so.
yes sir not at this stage
Kindly peruse the PWD3, Lordship.
we are not on trial sir I would not be appreciating evidence I would see whether the only thing that is disturbing us is the proximity of the accused with the victim
And Lordship, very defensive, Lordship FIR. And Lordship, accused take care of the victim, Lordship. The daughter-in-law, the informant have some conflict with the accused, the Lordship. Informant, daughter-in-law, Onita Hazarika. He has some conflict relating house of the partition of the house of this, it's residential house of partition of this, and her husband died in 2024. And after that, all the family take care of this by the accused, Lordship, the grandfather.
then why would the accused why would the victim a 5-year-old accuse the person who's taking care of everybody around him
In FIR that said that they go to school, but the other witnesses reveal that they go to with accused with her grand.
not at this stage sir
Kindly consider the age and the health related.
consideration of age would have been in the nature of the
And all
acquisitions
witnesses completed. Lordship.
huh
Almost all witnesses are complete. One official witness left on. Lordship. And after that,
the only thing left is your 313 statement and the arguments that would be another 2 months
Goes with the tries with the cows to one witness, Lordship, PW4, Rajiv Bora, Lordship. PWD4, he itself says that day the accused came with this.
was he doing something so lengthy with the small child that he could not go to tie cows
That day, Lordship.
what he has done to this small child would take him about
But,
2 or 1 or 2
side
minutes so
claim
I
to
don't know
The nearby house, lordship.
Could be.
And some conflict
Could
between
be.
the daughter and there's a informant with and
Not at this stage, sir.
Can you give me time for lordship?
Time for what? For you to argue further?
Lordship.
When?
Next week. lordship.
Let it. Huh?
Next week. lordship.
Next week. Okay. List again on the 26th of August at the request of the learned counsel for the petitioner, but yes, next week.
All right.
Case diary not there, sir? Charge sheet submitted, yes, sir. Call for the TCR or
My lord, may kindly come to page number 21.
can I
for
do it without nothing in his hand and nothing in my hand?
Lordship, just one line I will read.
Okay,
Page
yes.
number 21.
Huh?
On the last occasion, Lordship, case diary was here, Lordship, that day it was 58 days. This
Ah.
is, Lordship, intermediate quantity, 12 grams only. Page number 21, personal search was conducted, my lord.
Where is it?
Page number 21.
Huh?
So I apprised apprehended accused person so and so, so and so, so and so of his legal right under section 50 of NDPS Act to be searched in presence of the gazetted officer or executive magistrate or by me. The suspect consented to be searched by a male officer and accordingly search was conducted. So my lord, so far as this third option is concerned, lordship, or by me, that is, lordship, a clear violation as per the recent judgment of the Honorable Apex Court.
Saying?
Saying that, lordship, there should not be any third option, either before the magistrate.
What
or-
about 55? Section 55, what happens?
My lord, section 55 will. And before that, lordship, section
Oh,
50.
we are going with you. You are taking us before that. Tell us about 55. 50 within bracket 5.
Yes, lordship. Nothing. That is what, lordship, I was telling. I thought 55.
55.
Nothing.
Where?
In the city, lordship, it
That
would be
will
there, lordship.
require that therefore we would require the TCR.
Right.
Nothing to that to do. Once the TCR is here, nothing is revealed in the TCR. I can consider your legal submission.
Yes.
That is what I said 4 minutes
Yes.
ago. I have got a list to go. I wanted to do it quickly.
Yes, lordship.
You should also be accommodating.
Yes, lordship. Next week,
At the
lordship.
first go, you should be accommodating, not accommodating now.
I'm sorry, lordship.
List again on when? TCR, na? Scan copy of the TCR. A list again on.
Next Friday.
Here,
Uh,
search number we have got, my lord.
List again on 31st of August,
Right.
2026. Calling for the scan copy of the TCR. Since learned APP has submitted that a charge sheet has been submitted by charge sheet number
102 of 26, dated 19/8.
19/8/2026. Okay. Okay.
My lord, in 43, lordship, I have same submission. I am, lordship, making my submission so short, page number 22. Here also, lordship, personal search was there. Search was by the police officer, page number 22, paragraph number, second last paragraph, lordship. I found the suspect so and so, so and so, so and so, so and so. And there, a notice under section 50 was served upon the apprehended so and so, so and so, that is the petitioner, also asked apprehended person whether he should be searched in front of magistrate.
Yes, sir.
And case
Yes.
diary is here, lordship.
Case there is here, my lord. Yes, regarding 50, my lord, yes, NDPS item, materials of 25 grams, that is there. Regarding 50, that is the notice.
Now, the only thing is in
but-
section 50, in
Subsection.
section 50, he has said, would you like to be searched in front of a magistrate or a gazetted officer? But he has denied. Now, that is not the choice. The choice is, if I cannot take him there, then I can search.
Now once more, my lord, that is there, my lord, fake note also there. So regarding fake note, this is not necessary.
50 is not necessary regarding fake note.
FSL also available.
Hmm.
It's fake note.
Yes, sir. You were not prepared on the fake note part.
No,
We'll have it
lordship,
on Tuesday.
This is new, lordship, it is coming to.
No, there must be fake note written here also
No,
somewhere.
lordship,
It's my mistake, Lordship. I have.
It's all right, it's all right.
Let it
Happens.
be, Lordship, on
Tuesday?
Monday.
Monday?
Monday.
Only on the fake note part.
Yes, Lordship. Let it be, Lordship.
Okay,
Or-
list on 24th of August,
Let it be 25th, Lordship.
25th of August, 2026.
Highly obliged.
You have received the CD. Can be retained till then? Nice.
Highly obliged.
Please remind us on that day regarding the fake note. Otherwise, we'll follow.
Highly obliged.
44 years.
It please, your lordship. My lordship has fixed this matter today, my lord. It came up, your lordship, on Monday, my lord. That, my lord, page 17 is the affair, my lord. Some cattle were recovered, my lord, which are suspected to be stolen in the month of, my lord, May, my lord. The incident is in the month of May. Now the petitioner is arrested, my lord, in the month of August.
Cattle recovered on May.
May, mother, and the incident is of May. Then also it is strongly suspected these are stolen cattle. And now also it is strongly suspected, mother, these are stolen cattle, mother, from the forwarding report.
So many days, you could not find out whether they are stolen or not.
But from the grounds of arrest, lordship will find, mother, that here also they have stated that it is same thing, mother.
27th? Last opportunity for CD. Huh? Those who are required to be, where the bill is required to be rejected, we will invariably reject it. But where to find out whether it is to be rejected or not? We don't want the person behind bars for long. 28th of August, along with the CD at the request of the learned APT.
Obliged, my lord. But last time, my lord, on that day, it will be considered without it now not.
I have indicated, sir.
Yes, my lord. Obliged, I am grateful, my lord.
64.
মাজৰকেইটা কি হ'ল 52 53 52 53 বিলাক কি হ'ল বেল হিয়াৰিং নে এবি এইটা এবি আছিলে Yes. Ah.
This year he's not.
From where it is the PCR called for by the earlier order is not received. Registry to issue reminder. List again on BA. 7th of September
It's BA, madam. Okay, BA.
or
Lordship, kindly, short date may be fixed.
31st? 31st of August.
Lordship, name may be reflected.
Miss.
G. Kashyap on behalf of A. Sharma, Legal Aid Council.
Okay.
65 and 66.
Hello, this is the GST case, my lord. On the last occasion, your lordship was about to pass order. But the other side respondent, they said there is a judicial order to case to come up together, my lord.
Oh, yes.
That is the your lordship was about to give, my lord. That is my case, and I am a lady, my lord. All the
Yes,
electronics.
Mr. Chaudhary, we were about to give you tied our hands by saying that there are judicial order. Huh?
Lordship, the next item, AB. I'm appealing.
AB is not concerned, madam. I am behind the bar, my lord, being a
Both
lady.
arising out of the same.
It's okay. Tell us. Why did we want to give bail?
They have filed affidavit. That is not funded. It was filed on 19, Lordship. The website also reflected that I couldn't checked it out in the morning, Lordship. The affidavit was filed. Here, Lordship, the in the first item,
BA.
BA. Lordship, she gave a statement that the person in the AB was he had a negotiation with them. And now her custody is required further because Lordship will have the records. And there we have stated, Lordship, because some corroboration with the next Subrojit Bhattacharya, the next AV petitioner is required.
We will ensure that she participates.
Yes, yes, will participate, my lord.
Lordship,
She will be there whenever you require her. In any day she is absent, let us know. We'll recall the
Bail, my lord.
At any time.
Anytime, any condition, my lord.
She was arrested when?
20 July, my lord. And I am a girl, my lord. And I was beaten inside the jail by the inmates. My nose broken.
That, Lordship, I cannot say anything.
No, I am not saying about you, my lord, inmates.
Then where is the medical report, Lordship?
Aha. I was beaten, my lord, from
You are
LP.
delaying your own process. Your affidavit is not on
In
record.
the next item.
In the AV.
Subrat,
In the AV, it is,
take-
it is not on record. To Monday Didyok, along with the affidavit filed in WPC in BA number
1752.
IAB number so and so. You have the case diary and everything ready.
Yes, sir.
24th first half. Monday first half, both of them together with the affidavit. Next time they'll say that the affidavit was not there, therefore we were indicated.
My lord, some interim also.
7 more minutes, sir.
7 more. Lordship,
Next, we'll do it on Monday.
Monday.
Continue, madam. Maybe.
The interim order in the in item number
66.
66 continues. Monday.
Monday. Faster.
47, no CD.
May I please, your lordship?
Interim
is there, lordship. Case diary was called for.
It is not yet received, madam.
CD is awaited. Interim order passed earlier continues. List again on
29.
29.
Highly obliged.
Yes, 48. Case diary is not received.
Submit, submitted.
Case diary not received. Charge sheet submitted. The learned APP submits that the charge sheet has been submitted. None appears for the petitioner on call. List again on 25th. Allowing the petitioner to appear. 52, nothing. Ketat bench rising ketat dekhaiছে bench kon ketat rise kori dile 315 ne 3
52 also success submitted. None appears.
learned APP submits that that a charge sheet by CS number
CS number 126 of 26, dated 30526.
has been submitted. None appears for the petitioner on call. List again on 25th of August, allowing the petitioner to appear.
May it please your lordship, lordship, this is an anticipatory bail application, lordship, two petitioner before this court, lordship. Petitioner one is the General Secretary of Bodo Student Union and petitioner two is the game secretary, lordship. Here FIR, lordship, will find on page 15, lordship, one person, lordship, from Arunachal, lordship, Jimmy.
Malab, time is short, malab, I am just coming, malab. Do malab. Incident of Bipuria. Some around 15% of Arunachal they came, malab, and malab assaulted the malab information, malab husband, malab in his house, malab, and vandalized something, and from breaking the locker, taken away 20,000. There were 3 rounds of firing also, malab. But the person identified only by the husband and wife, all malab, wife also assaulted. One person was by name, malab. Others malab, they didn't, malab, they take also only malab, one name, Gumin means.
He was released on bail.
And he,
So we'll allow them to appear.
He fired.
We allow them to appear, give their statements.
The main accused, other
Main accused is already gone.
already gone, and malab, regarding them, no specific that these are the persons. Malab.
You have the case diary with you.
Malab.
So we'll ask them to appear before a particular date. Should we call for the updated case diary or we can? Okay. Heard Mr. So-and-so learned counsel appearing for the Mr. B. Chaudhary learned counsel appearing for the petitioner. Also heard Mr. K. Parashar learned APP. The learned counsel for the petitioner has submitted that the petitioners are not involved in the present case. And in fact, the named accused, the identified accused, one of the identified accused who was arrested has been granted regular bail by this court. So accordingly, he prays that the petitioner's hearing may be allowed to appear before the investigating authority and participate in the investigation process under protection. Full stop. The learned APP has submitted that as per
Witness has
the
not taken the names specifically.
huh?
Witness has not taken the names specifically.
The learned APP has submitted that as per the case diary, the named accused, the person, the identified accused has in fact been released on bail by this court, and the petitioners have not been named as identified as accused or participants in the offense alleged. Full stop.
Not by this court, no. Court below.
Huh?
Not by this court, court below. only.
Oh, by the court. The upon consideration of the materials available on record and the materials available in the CD, I am of the considered opinion that the petitioner in these cases shall appear before the investigating officer on or before the 7th of September 2026 to participate in the investigation process, full stop. In the event of their arrest, they shall be released on bail on furnishing bonds of rupees 10,000 each with one surety of the like amount to the satisfaction of the arresting authority, full stop.
In connection, Bihupuria PS case number 72/20.
That part you will always write, huh? That part, huh? Bill in connection with so and so, huh? Application under 482 in connection with Bihupuria police case number, that will be on the top, and you have to give the name of the petitioners also. Huh? According to
Highly obvious.
petitioners, so and so will be released on bail.
Highly obvious.
54, I am appearing.
BA, there is a BA also.
No, it is also adjacent.
Both are AB, same condition, same thing, same order. Both cases. One will be heard Mr.
B Kaushik.
B. Kaushik.
Grateful.
55 submitted.
55 charge sheeted, sir. You want to pursue your remedies there or we call for the PCR?
Appear before the.
You'll appear before. Heard Mr.
SS Ahmed.
Heard Mr. S.S. Ahmed, learned counsel appearing for the petitioner. The learned APP, Mr. K.K. Parashar, has submitted that the investigation has culminated in charge sheet number.
253/26 dated 307/26.
Learned counsel for the petitioner has submitted that the petitioner may be granted the liberty to approach the trial court as and when summons are received for trial, if any, full stop. The anticipatory bail petition is closed, granting the liberty prayed for. Yes, madam.
Lordship, on last occasion, Lordship has made some query, Lordship, regarding medical documents.
My lord, here I have received some documents, my lord, medical document, my lord.
You want to go through?
My lord,
We can have it on Wednesday.
Lordship.
You are on interim.
No, Lordship. Accused
Huh?
number one is not on interim.
not the case of interim, my lord, here.
Two and
The
three.
POCSO matter is there, my lord.
Two and
Can you
three
fix
is
it
on
on, madam?
interim, Lordship.
Tuesday or Wednesday, my lord?
Just a minute. Three petitioners.
Yes, Lordship.
Two are on interim.
Yes, Lordship. Lordship, we have lost the FIR first, Lordship. On page.
First and second doesn't matter, madam.
Lordship, that is the actual fact, Lordship.
Huh?
That is the actual fact, Lordship, in our FIR, Lordship. And petitioner number one is suffering from.
We'll have it on Monday.
Not my-
Tuesday, we'll have it on Tuesday, madam.
Lordship, kindly on Monday, Lordship.
Tuesday, she's not there. Amika's not there. Again, I'll list it on Tuesday. What will be the?
Lordship, this is the fourth or fifth time.
No, he has got the instructions. It is the shortage of time because it is 3:15 that we have to rise. We have a reference today. Are you aware? There is a reference. We have to rise. There is a order. Ki thakile?
God bless.
I told Tuesday, diok, huh? List again on Tuesday.
Tuesday, madam.
This will be on Tuesday. At the request of, due to paucity of time, list this matter again on Tuesday. Yes.
Number 17, 18 and 19, my lord.
17,
It is
18,
the fact
19.
matters,
Yes.
my lord.
Huh.
Pertaining to a matrimonial dispute in there is a stay order in a DV case. We appear for the respondent. So, my lord, may I pray that a date may be fixed, my lord?
We'll have it on sometime 11th or 14th
My lord.
September.
My lord.
Take a choice. 14th September. Item number 17, 18, 19. Due to paucity of time and at the request of the learned counsel for the petitioner, list again on 14th of September. Yes, sir. Huh.
On Wednesday.
Wednesday, item number 20. Due to paucity of time today, list the matter again on 26th of August 2026.
Lordship, item number 57, it is wrongly come in the orders column, Lordship. Let it come in admission, it is not admitted yet.
Item number
57.
57. Learned counsel for the petitioner submits that the matter should be listed for admission instead of for order.
Order.
Full stop. Accordingly, list this matter again after a week in the admission column.
Fix that, Lordship.
Then it is.
It is person is in behind the bar,
Okay. 31st of August.
31st. Obliged.
Item number 59, there is an interim today, only for today.
In item number 59, due to paucity of time, the matter could not be taken up today. Full stop. List the matter again on the 3rd of September 2026. Interim order passed earlier continues.
Item number 17, 18, 19, already mentioned, the interim order will continue.
The interim order in 17, 18, 19 will continue. Yes.
Item 21, may I pray for a date?
Date he will adjust. You tell him a date, we'll adjust. Any dates he will, the court master would oblige.
Item number 52. Apologies for coming late. So search sheet have been submitted today only. So AB may be allowed.
No, AB will not be allowed. We'll close the AB because you will not be arrested any further by the investigating authority, and you would approach the learned trial court as and when you receive your summons. That will do. Item 52.
52.
Item 52. AB closed. Apne ekdam short only. AB closed. CS submitted. Approach. LTR. When summons received. Hetu order bhai dibo taman.
Lordship,
Bamo likhai dim. CS number, item number 52, CS number, or the belege paise, kuna paise.
Lordship, someone have already, they have received the summon on 14th.
So
And the
go
date
in
was
appear.
15th.
Go in appear, ask for regular bill, they'll give up regular bill.
Obliged.